Chief Justice, with your leave, I'll ask the clerk registrar to call the case.
Good morning. I'm the registrar clerk for this hearing. Chief Justice and Justices of the Constitutional Court. All counsel are online. I call the matter of Competition Commission of South Africa and Mediclinic South Africa Pty Limited and another.
May it please the court, Chief Justice and members of the court, I appear for the Competition Commission together with my learned friend, Ms. Nkloko.
Thank you, Mr. Mane.
May it please you, Chief Justice and Justices. Ms. Norton, Mr. Mbikiwa, and I appear for the respondents.
Thank you, Mr. Tucker. Mr. Butler, I'm sorry. Yes, Mr. Manager.
Thank you, Chief Justice. What we need to persuade the court this morning is that, firstly, that this court has jurisdiction and it's in the interest of justice that leave to appeal be granted. And secondly, we need to persuade the court that there is a basis on which this court should interfere with the judgment of the CAC as well as the order granted by the CAC. Now, in doing that, I'm going to follow the following sequence. I will deal with the price effects on uninsured patients. Then I will deal, secondly, with the price effects on insured patients. And in addressing both of those, I will make submissions that show that this court has jurisdiction, that the matter engages the jurisdiction of this court. And secondly, I will also highlight what we submit are errors and misdirections on the part of the CAC that justify interference by this court. And if I still have time left, I will deal with any remaining competition concerns, and I'll briefly simply summarize on jurisdiction and interest of justice and conclude. On that basis, then, I turn first to the price effects of the merger on uninsured. Before I do that, let me just highlight some points about the price effects on uninsured and insured. In the address that I will make in relation to those, I will show that the appeal in fact engages the jurisdiction of this court under both Roman 1 and Roman 2 under 167(3)(b). And the key reason we say it engages the jurisdiction of this court, the constitutional jurisdiction of this court, is that we submit that the judgment will and the order will adversely affect the right of access to healthcare, and that the CAC failed to follow a constitutional approach, which is required by Section 39(2) in its interpretation of the relevant provisions of the Competition Act. So our argument is different from that in Media 24 on the constitutional issue. It's more similar to what was raised in the case of NUMSA and others versus Beidabob, which is 2003 2 BLLR 103 judgment of the Constitutional Court. There, in relation to the constitutional issues, one of the issues that arose was the argument by the applicants that the interpretation adopted by the majority of the LAC constituted an infringement of their constitutional right to strike. And the court, this court found no difficulty concluding that that was indeed a constitutional issue. There may be slight differences, but that's in approach what we submit key to our submissions. What is similar to Media 24, though, is that the points of law that we raise on the Media 24 approach are clearly points of law which are arguable and of public importance, and I will highlight those in the course of my address. And those are a number, and some of them will illustrate that the CAC, in fact, the majority, failed to follow its own previous decisions. In other words, did not follow the doctrine of precedent and chose to approach the matter differently. And that arises in a number of respects, which I will indicate. And then I will also deal, as I submitted, with various misdirections. What we say are misdirections by the CAC, we justify the interference. And so against that backdrop, I just start with uninsured patients. And it's important to emphasize that the case for the Commission on Uninsured Patients is based on facts which are common cause between the Commission and the respondents. That's the first. The second important issue to highlight is that the court does not have to determine what the geographic market is. It can accept the geographic market which the CAC determined, that is, that this market comprises Klerksdorp separately and Potchefstroom separately. And we will show that even on that finding by the CAC, its conclusion that there were no substantial public interest considerations which would justify the prohibition of the merger is, to say the least, unbelievable, but at a more fundamental level reflects an unconstitutional approach to this issue. And that is followed by the respondents in this case supporting that approach, and we submit that that's a wrong approach. So what are the common cause facts? The common cause facts we summarize in our heads of argument at paragraphs 57 to 65. I don't wish to take you necessarily to those heads, but the first is that uninsured patients are not members of medical schemes. That's the first. The second, because of that, they enjoy no protection from any agreements on tariffs and any related elements of agreements which are concluded between medical schemes and private hospitals. The third is they pay from their pockets. And you will have seen in relation to Mediclinic, although they have provision for discounts for private patients, when you want to enjoy that discount as a private patient, you have to pay your full hospital bill upfront. And the fourth point, which is common cause, is that the target hospitals offer far cheaper prices than the Mediclinic hospitals, the Mediclinic group as a whole. And it's important just to pause there that these prices are significantly different in circumstances where Mediclinic claims that it is more efficient. So despite the claimed efficiencies by Mediclinic, its tariffs for private patients are significantly higher than the tariffs for private patients offered by the target hospitals. And because, as was discussed earlier, there's some reservation about disclosing all these numbers publicly, I asked the court to turn to the judgment of the CAC in volume 35 and to turn to page 3494 of that volume. And for purposes of my address in relation to uninsured patients, I just ask you to refer to paragraph 25. Later, I'll ask you to contrast it with paragraph 24 to show you how significant the difference is, the impact will be on uninsured patients. So you'll see there that first, the tariff component of the target hospitals for uninsured patients will rise substantially post-merger because the higher Mediclinic tariff will be used at the target hospitals. And you can see the difference there in percentage terms, a double digit in the third line. That's the difference. So Mediclinic is higher by the magnitude you see there. And in addition, so that's the first difference A. The second difference A is that the target hospital managers have discretion to grant greater discretionary discounts than Mediclinic hospitals. And you can see they can grant up to that percentage, double-digit percentage, as against the Mediclinic percentage, which is a single figure, single digit that you see there. Now, just pausing there, that's the first difference about the discounts. But the other difference about the discounts is that the double-digit percentage for the target hospitals applies to theater time. So when you're lying in the theater and they're operating on you and they're using surgicals and whatever, all of the things they would deploy to operate on you, the tariff that is calculated for purposes of your final bill in relation under the target hospitals also enjoys that percentage, the double-digit percentage discount, as well as the hotel portion. I call it the hotel portion. That is when you're now in the ward and you are admitted. That double-digit applies to both. But the difference with Mediclinic is that their single-digit only applies to the hotel portion when you are in the ward, but it doesn't apply to the to this theater time and the tariff that follows. Now, you'll have seen from the papers that all of the experts and the parties agree that what matters to the final patient, it's not the tariff, it's the final bill that you pay. And that is calculated as an efficiency adjusted price and is called CPE. In other words, when they have taken into account all the efficiencies that they claim, that they're going to sell their surgicals at lower prices and they're going to select generics so that you don't pay a lot more, all of that is accounted for in this efficiency adjusted price, and that represents the final bill to the patient. Now, the CAC calculates the impact of the tariff increase that I showed you earlier, the tariff difference, on the final hospital bill for the private patient, and it says it will be in those double digits. You can see there where it says that CPE for uninsured patients would rise by that figure to that figure. So that's the real price increase that a private patient in Klerksdorp will experience if this measure is permitted. And now it doesn't stop there, because this price increase that you see here, of course, doesn't take account of the differences in discounts. So the impact on the uninsured patient is probably higher than what you see calculated by the CAC. I raised this, a connected point to this is that you'll also have seen in the CAC judgment that when it looks at insured patients, which you see at paragraph 24, where the impact on the final hospital bill for the patient because of the tariff difference is lower than for the uninsured patients. If you look at the fourth line from the bottom of paragraph 24, you see it says, and surgicals, this will cause the target CPE to rise by, and it gives you a single digit number. That is the price increase for insured patients, which takes into account all the efficiencies. If you just deploy the tariff increase from the Mediclinic onto the target hospitals.
Your 10 minutes is up, Mr. Manager.
Yes, it always takes me by surprise. But the point I'm trying to draw the attention, what I want to draw the court's attention to is when you look at 24, you see the CP impact of the price differential is going to be a single digit. And I've showed you for private patients, it's going to be a double digit, not even factoring in the discounts. Now, I say at this very early stage, if you then having read paragraph 24 and 25, you then ask yourself the question, if the CAC at paragraph 213 says there is not going to be a substantial public interest, there's no substantial public interest concern in relation to the uninsured patients, because efficiencies claimed by Mediclinic will offset this double-digit increase to the final bill for a private patient. You just ask yourself that question, Chief Justice and members of the court. You will not find any reasoning in this judgment which shows you how this double-digit number can ever be offset. But you reach the conclusion that there is no substantial lessening of competition for uninsured patients, and there is no substantial public interest consideration as a result of this significant price increase. The reason you don't find it is that the majority judgment gets caught up in discussing efficiencies for insured patients and is blindsided not to recognize that the merging parties never presented any calculations on efficiencies in relation to the uninsured patients, and they admit so in their heads of argument. So instead of the CAG saying, I have no basis to reduce this pricing increase on uninsured patients, you get a conclusion, unreasoned, we submit, that there is no substantial public interest. So we say that's not only wrong on the facts, but is an unconstitutional approach to the right of access to healthcare. And I will show the court how that arises in the context of the discussions of the provisions of the legislation. So this is a good place to start to see the point I wanted to make. And
Mr. Manager, I'm sorry.
Yes, Justice Jafta.
The scheme of Section 12A. Tell me if I understand it incorrectly. I thought at the first stage, what needs to be determined is whether there is a likelihood of a substantial lessening of competition. And then if there is, you can move to whether that is offset by technological efficiency or other anti-competitive gains, or the public interest. So as I understand your argument, does it deploy the public interest question because there is an assumption that the first leg has been met? Or does it deal with both in the same time? So I just want to get clarity on that. I understand that you say the CAC has misdirected itself in coming to the conclusion that there would not be a substantial lessening of competition with regard to uninsured patients. I'm not quite sure whether I've articulated the question clearly for you to understand.
Yes, I understand completely. So Justice Jafta is quite right. So I simply painted the factual scenario, but quite rightly, the court needed to first start with whether this effects on the uninsured would result in a lessening of competition or not. And only if the answer was no, to then move to the public interest. What the CAC did was to ask the question whether this change in pricing for the uninsured must be addressed as a competition issue, in other words, in the first leg, or it's only a public interest issue. And it concluded, having determined that Section 12A1A, according to the CAC's interpretation, only applies if there has been a change in market structure, which creates an enhancement in market power. It says only then the pricing effects are relevant to the competition assessment. And that is the first legal issue we say, well, it misdirected itself just from the starting blocks. And I want to demonstrate, I can tend to demonstrate that. And then the second point related to the question is then it says, because we find that this pricing effects do not belong under the competition assessment, we're going to look at it as a public interest issue. And then under public interest concluded that it's not substantial.
Okay.
So we submit that it aired on the legal point, the first legal point about this pricing issue are not relevant to the competition assessment. And then it also erred when it dealt with the public interest concern. And the reason I started with the facts is that these facts inform both legs of that debate.
Okay, you would appreciate that we are accustomed to having first the determination of the law.
Yes.
And apply the law to the facts. Now, you started, that's why I got confused. You started with the facts before you got to the law. Okay.
Yes.
Now I understand why you adopted that strategy.
Yes. So I just wanted you to have a bird's eye view of when you're looking at the law, it's not all cold, but is against the backdrop of these facts. And I'll come back to the facts when I deal with the, first, let me just complete the facts because it'll lead the court to the first inquiry about competition and see how the court erred in that regard. If I can take just a few minutes on that point. So I've referred the court to paragraph 25, and the next point, which is important, is that the CAC accepted that if the prices to the uninsured patients in Klerksdorp as the market, where the target hospitals compete with Life Encron, which is the other hospital, that if the prices of the target hospitals to uninsured patients go up, they have these consequences. The first is that they take away the ability of private patients to bargain on price, to bargain for the cheaper option, which is provided by the target hospitals. So it limits their ability to switch and bargain prices down. And we would submit that when we get to the section, that's in itself lessens competition in that market because consumer welfare is reduced. The keen competition between the two hospitals is also affected, and that also the CAC accepted, which is that the Life Encron's likely reaction to a competitor who is now more expensive than it would be to raise prices as well. And you will see that in the CAC judgment, paragraphs 137 and 139. So you bear in mind, there is a common cause CPE increase of significant amounts, and the acceptance by the CAC that will lead the incentives of the competing hospital to also raise prices because it doesn't need to give deeper discounts in order to drive custom out its way. So you lessen competition there as well. It's a lessening of competition.
But Mr. Manuchi, while you're dealing with the facts, can this court find in favor of the commission and prohibit the proposed merger without overturning factual findings that were made by the Competition Appeal Court? And in particular, can we find in the commission's favor if we do not interfere with the appeal court's, the Competition Appeal Court's findings in relation to the possible increase in CPE post-merger?
Well, so you can because you will find a misdirection, a clear misdirection. So I have pointed you in relation to the uninsured patients that in paragraph 25, it tells you of the significant increase in CPE. And then you as the court must see the thread in reasoning by the CAC to the conclusion that there is no substantial increase either in price for uninsured or substantial public interest consideration.
So you accept that we will have to overturn factual findings made by the Competition Appeal Court?
No, what I'm submitting to the court is that you will reach a conclusion contrary to the Competition Appeal Court based on its own factual findings in relation to the uninsured patients, which is what I'm dealing with right now. So you will find that on the uninsured patients, given the factual findings which the CAC made, it could not reach the conclusion that it reached. So I'm not asking you to find that there was no price increase for uninsured. You accept what the consequence in paragraph 25. And you also accept when the merging parties say there was no calculation of any efficiencies as against uninsured patients, and their claim is that because they had limited data for that. And they say that in their heads of argument. If I can, that will be at paragraph 113, page 38 of the merging parties' heads of argument. They made it clear that before the tribunal, there was no quantified evidence of any efficiency that would counter the significant increase in price for the uninsured patients. And just while on that, Justice Teron, if we go back to paragraph 24, and having read the record, you'll recall that the only quantified efficiency is the single digit that you find in the fourth line from the bottom of paragraph 24, where it says, in surgicals, this will cause the target CPE to rise by that amount. So that's the only quantified efficiency that was proved and which the CAC accepts. Now, even if you take that and you give them credit, that cannot reduce the double digit that you see in paragraph 25 to avoid a price increase, a substantial price increase for uninsured. You still end up with a double digit increase. So the point I'm making is this, that you can say, we accept what the CAC says at paragraph 25. We accept the merging parties saying that they did not quantify any efficiency in relation to uninsured patients. So what you're left with is this significant price increase. How could that, and we will submit, how could that ever, first on the competition inquiry, which I'll come to, Justice Jafta reminded me of that, and also on the substance, on the public interest consideration, you'll see we submit, there is, other than that there was a misdirection, there's no way in which one could conclude that this is not a substantial competition concern or public interest concern. If I can then go to the issue that, that Justice Jafta quite rightly raised, is that we submit that the first legal issue that this court will grapple with, first arguable point of law, relates to the court's, the CAC's interpretation of section 12, capital A1A. In other words, the competition inquiry. And I think what is important here for purposes of this is to go to the section itself so that one sees what the CAC did by reference to the section itself. So section 12A1 says, whenever required to consider a merger, the Competition Commission or Competition Tribunal must initially determine whether or not the merger, the transaction, is likely to substantially prevent or lessen competition by assessing the factors set out in subsection 2. And if it appears that the merger is likely to substantially prevent or lessen competition, then determine the efficiency gains under A and the public interest concerns under B. And it does the competition assessment by reference to subsection 2. Now we emphasize firstly that the inquiry requires the competition authorities, including the CAC, to consider whether the merger has the effect of reducing, of lessening competition. It's a measure you're looking at. And you look at the factors in subsection 2, and you will see those factors listed do not include any change in market structure or enhancement of competition, of market power per se. So the various, B is barriers to entry, and C is concentration in the markets. Those are, and H, if I can refer to it, is removing an effective competitor from a market. So those are factors, but they're not a closed list. But all of those factors are intended to assist the competition authority to determine what effect the merger will have on competition in the relevant market. But how does the CAC approach that inquiry? And here I ask the court to turn up paragraphs 98 of the CAC judgment, and that is page 522. And this is really relating to the question Justice Jafta asked at the outset. So he says implications for market definition. Recall he's disagreed with the tribunal's market definition, but now he's turning to the competition inquiry. He says in 98, because Potchefstroom and Klerksdorp do not fall in the same local market, the measure will not give rise to an SLC in relation to the local market within the meaning of section 12A1. There are currently 3 multidisciplinary hospitals in Klerksdorp, 1 owned by Life, 2 owned by Matlosana. If the measure is implemented, the market structure in the Klerksdorp market will be unaffected. The 2 Matlosana hospitals will simply have a different owner. The new owner will have no greater market power within Klerksdorp market than Matlosana currently has. And then he says, accordingly, any post-merger price increases at the target hospitals will not be a consequence of a lessening of competition. And then he says the same is true of the tribunal's prediction that there will be a deterioration of quality. I just stick with price. And then if the court tends to paragraph 125, which the court will find at page 3531 in this volume 35, he says, the fact that the tariffs will immediately increase is not a consequence of an enhancement in Mediclinic's market power. Mediclinic's negotiated scheme tariffs and its private tariffs apply uniformly to all its hospitals in South Africa. Mediclinic will have no greater pricing power in Klerksdorp than Matlosana and NHN currently have. The tariffs which Mediclinic will implement are tariffs which have already been negotiated or set for uninsured patients and are thus set at levels uninfluenced by the merger. In post-merger scheme negotiations, Mediclinic's marginal increase in national market share will not give it greater pricing power. And it's because of this conclusion that he then says that at paragraph 128, just to complete that at 3532, page 128, he says, because of that conclusion that he's just reached, that there's no change in market structure, he then says the fact that price effects must in the present case be assessed. He concludes in 127 that because of that conclusion, the price effects here must be assessed only as public interest. So he's limiting, if the judgment stands, he's also limiting the power of the tribunal to look at price effects where they can't show change in market structure. They can only look at public interest and not the competition assessment. And he says at 128, the fact that price effects must in the present case be assessed in the context of public interest rather than SLC has an important effect on the evidence dealing with the relative efficiencies of the target hospitals. And you will see, he says, under public interest, the merging parties have no owners, no evidentiary burden. And we'll show that that's a departure from a previous judgment, but that's under public interest. The point I make is that this approach at 98 and 99 and 125 find no support in the language of section 12A, capital A1. That section doesn't say the tribunal or the CAC must determine whether the measure results in a change in market structure or enhancement in market power. What it asks is whether it has an impact on competition. It may impact competition in many ways, other than simply by a change in market structure. The one impact is the one that the CAC itself accepts, as I said, at paragraph 137 and 139. And may I take you there? So he says, at paragraph 137 at the top at 3536, although private patients will be able in most specialties to turn to Ancron if they find Mediclinic's prices at the targets unacceptable, their choice might effectively be inhibited by price increases at the targets. Furthermore, if Mediclinic's prices for uninsured patients rise, Ancron will have less incentive to grant discounts. Overall, prices for uninsured patients in Klerksdorp might thus go up. We submit, given what he says in paragraph 25, it's clear they'll go up. It's not a might. But what it says here in paragraph 137 is this measure will have an impact on the competition between Life Ancron and the target hospitals in Klerksdorp, which will have a pricing effect because Life Ancron may also increase prices to its own patients because it doesn't have to compete with a cheaper hospital anymore. but as a business, it must make profits. So it's going to increase prices. That will mean that even the volumes of patients that this hospital may realize when the prices go up may be affected. So that's an access issue, which I will come back to under public interest. So what I'm submitting is on the conclusion he reaches on the interpretation of 12A1 is not supported by the language, but is contradicted by the facts he finds, because the facts he finds shows that there's going to be a dampening of competition in the market he's defined as a result of the merger.
Mr. Maneche, does private patients in the judgment refer to uninsured patients, or what does private refer to?
Yes, I think I also have used the words interchangeably. Private patients are uninsured patients. So insured patients will be those that are covered by medical schemes.
Is a possible subtext perhaps not the fact that according to the evidence, it's only what, a couple of hundred, there is only a couple of hundred uninsured patients, and that therefore that goes to the question of substantiality. I'm not saying that would be correct, but it's a point that the respondent raises.
Yes, absolutely, Justice Madanga. In relation to competition, the question of substantiality, and we refer to the NetStar judgment, which dealt with that concept in the context of section 4.1a, which talks about horizontal agreements which may cause a lessening of competition, which must also be substantial. It says that tells us that the lessening must not be trivial or speculative. It's not to say that if you have a market, and this market, the product market is common course. It is a market for multidisciplinary acute hospitals. It serves all patients, insured and uninsured. Now, a pricing effect such as this, which is significant, would be substantial if one has regards to the purposes of the Competition Act, even under section 12.1a, because that purpose is to ensure that customers have choice and customers have access to cheaper prices. So on the purposive interpretation of the provision, it's difficult to understand how you would say, well, they are small, they are not commercially significant to me as an operator, and as a consequence, their effect is not substantial under the Act. We submit that is to take a very narrow approach to the Act and to forget the broad purpose of the Act. And Justice Madanga, what is important is that there is a previous judgment of the Competition Appeal Court in Mondi, which sounded precisely the kind of caution that I'm referring the court to. That was in the context of an intermediate merger, and the court was cautioning against borrowing concepts from foreign jurisdictions about what merger regulation is about. Because the arguments there was, well, this is not changing market structure. There's no enhancement of market power. Market power is what you're regulating. The ex-ante regulation under the Competition Act is aimed for. And the court said, no, you must pay regard to the purposes of the Competition Act. And it's important to read, we've given the reference in our heads, but paragraph 47 and 48 of that judgment are quite important. It says, 47, the examination of theoretical approaches has been conducted without recourse to the Act. Grassi et al. Competition Law at 30 suggests that ultimate concern of merger control is not with dominance, which is the same as enhancement in market power, or what amounts to much the same thing, the number of participants in the market, but is concerned with the greater harm to the market that large firms can potentially wreak. Because they have market power, they can charge whatever tariffs they want. Paragraph 48 says the assessment of harm has to be analyzed within the specific framework of the Act. This inquiry necessitates recourse to the preamble to the Act and the purpose thereof as set out in section 2. These are imported sources of interpretive guidelines, see section 1.2 of the Act. Thus, care must be taken before an uncritical borrowing of traditional antitrust economic theories as developed in the United States of America encrust the process of interpretation of our Act. Unlike much comparative competition law, the Act specifies, among others, overall its purpose of the maintenance of competition. Important. So this measure does not maintain competition in Klerksdorp, has the opposite effect. Maintenance of competition, also that small and medium-sized businesses have an equitable opportunity to participate in the economy, and that there be promotion of a greater spread of ownership, in particular to increase the ownership stake of historically disadvantaged persons, and that section, and reference to section 2E and F. Now, this reference to the purposes of the Act echoes in my submission what Justice Theron said in Media 24 on whether the issue raised there was an arguable point of law, that it's asking for the normative policy reason why you have the provision. And this CAC judgment answers that question. But what the CAC in this case did was to depart completely from this and import its new test that there must be a change in market structure, which results in an enhancement of competition before a price increase such as this could be assessed under competition. So we submit that that's the first error.
Mr. Maneche, may I ask you on that point? We are discussing substantial lessening of competition. And now the respondents argue that this was an automatic price increase as a consequence of the merger, would be because of rationalization of operations, leading to inter alia lesser operational costs. And therefore, that automatic price increase does not necessarily point to lessening of competition. What do you say of that submission?
Well, with respect, that's the submission they made to the CAC, and the CAC bought it. It's a wrong submission because that's not what the Act says. The Act says, look to see whether the merger will have a substantial lessening of competition. We have a pricing effect. Now, the CAC itself accepts that this pricing effect will have consequences for the competitor to the target hospitals. It too will increase its prices. It too will reduce its price competition against the target firm because it no longer has a cheap opponent, if I can put it that way, to face in competition. Now, there is a clear lessening of competition as a consequence of the merger. There's no debate that those consequences are not merger specific. In other words, they don't result from the merger. They result from the merger. And you will also see, with respect, the inconsistent approach of the CAC on this interpretation, that when it dealt with public interest, and the merging parties also argued that this case does not raise the public interest considerations under 12A3. They said that refers to region, but we are referring to people. And the court said, but we're not here in an esoteric debate. The regions are populated by people. If the merger has an effect on people in a region, that falls within 12A3. So it focused on the effect of the merger in the region. But here, instead of focusing on the effect of the merger in the market it identified, it chose to ask a different question, whether there is a change in market structure. And the CAC itself previously sounded this warning, don't depart and borrow tests without regard to the Act itself. I think Justice Theron has a question.
Yes, thank you, Mr. Maneche. If I can refer you again to paragraphs 99 and 125 that you made reference to a few minutes ago of the Competition Appeal Court judgment. Didn't that court make a factual finding, a finding based on the facts that were before it? And I'm referring to the first sentence in paragraph 99, that any post-merger price increases at the target hospitals will not be a consequence of the lessening of competition. Wasn't that a factual finding? And if one looks at paragraph 125 as well, the first sentence, it says, the fact that the tariffs will immediately increase is not a consequence of an enhancement in Mediclinic's market power. Now, wasn't those findings made based on the facts that were presented to the Competition Appeal Court and would have applicability as between the parties and this matter?
Well, it seems to be factual findings, but one must understand the premise of those factual findings. The premise is the test to determine whether there's an SLC is whether there's a change in market structure in 98. So it's clear that once he finds that there's no change to market structure, he'll conclude that there is no SLC because there's no change in market structure, so there is no enhancement of market power on the part of Mediclinic. He can only reach these conclusions he reaches here, but they are premised on a misdirection as to the interpretation of 12A1. So if you didn't have 98, probably my argument may be difficult to make. If you didn't have 98 and he simply did not pay attention, he did not say what you're required to show, and he simply reached a finding that there has been no SLC, Justice Taron, the point you raised may be warranted. But here, in other words, if I say a murder is the intentional killing of a human being, it follows that if in the facts I'm not going to find the intention or I'm not going to find a killing, I'll conclude that there is no murder. But if my definition contains a misdirection, the consequence, the conclusion on the facts itself is misdirected because I'm testing it against the wrong test. That is really our submission.
Where in paragraph 98 do we find the definition that you say may be wrong? Where's the statement of law in paragraph 98 that might be wrong?
So he says, because Potchefstroom and Clarkshop do not fall in the same local market, the merger will not give rise to SLC in relation to the local market within the meaning. And then he tells you what that meaning is that he says, there are currently 3 multidisciplinary hospitals in Klerksdorp, one owned by Life, 2 owned by Mediclinic. If the merger is implemented, the market structure will be unaffected in that market. The hospitals will simply have new owners, and the new owner will have no greater market power. So it is not a lessening of competition within the meaning of 12(1)A. He doesn't say so, probably because he might have assumed that that is the way 12(1)A should be interpreted, but that flows from his interpretation of the meaning, and we would submit in the ambit of that section. And in order to determine whether he is right, this court has to go back, or we are right, the court has to go to 12(1)A and say, what is the meaning of 12(1)A? What is the approach to be adopted by the competition authorities? And once it's determined that meaning, then it can look to see whether the pricing effects we say will arise here fall within that test or don't fall within that test. But that's an interpretation question, which is a legal question. So that the other important point goes back to what Justice Jafta asked me at the beginning is, if the CAC had assessed the price effects within section 12(1)A, and it concluded that there was any price effect, assuming it did, then there would be a trigger for the merging parties to discharge an onus to show that the efficiency gains that they say they will achieve outweigh that competition effect. But because he said this is not a competition assessment, it's a public interest assessment, he said there is no onus on them. So he says all he does is to look at the public interest consideration, look at the efficiencies, and just weigh them in the wash, in the balance, and see where one comes out. And we'll show that even that is wrong, because the efficiency gains are only relevant to the competition assessment and not to the public interest assessment. And the CAC has said so in the past, and the court ignored that. So that's the first error we submit of law that we say the CAC made, and has consequences because it relieved the merging parties of an onus that it should otherwise carry to displace the anti-competitive effect. Now, I've showed you the effect, the pricing effect on uninsured patients, and that there are no quantified efficiency gains which the merging parties presented, and they admit before the tribunal that would outweigh that significant price increase for uninsured patients. So if they truly carried the onus they would not be able to displace that onus. They would not have been, and they would not be able to. Even now, they can point you to a discussion of the efficiencies that would be attributable to uninsured patients, which will offset any pricing effect. They can't do that because they admit they did not do any quantification.
So
Now,
the upshot of your argument then is that the increases in percentage terms in paragraphs 24 and 25 would stand absent evidence on the efficiencies.
Yes, but only because I'm focusing on uninsured patients is the numbers in 25.
Oh, okay. Or 25.
Yeah, because 24 is insured, is the bigger numbers
Yes.
in 25.
Yeah, I put the two together because I would
Yes.
imagine the efficiencies apply to both, but I understand you. Yeah.
Yes, so even assuming they apply to both, all that they, at best, they've quantified 6%, but the increase for uninsured patients is significantly higher. So that you're not going to reduce. And we're not for the present, I mustn't be understood to accept that the 6% is going to stay because there's the procurement exemption, which comes up later. I think Chief Justice might want to warn me about my time.
Yeah, I thought, no, it's not about time. You were very careful not to specify the percentage earlier, and I assumed that it had to do with the understanding that you have with Mr. Butler. So yes. Just in case that is so, I'm just cautioning that you stick to that understanding.
Yes, I think I might have slipped. Yeah, and I only realized now when the question is raised, Chief Justice, yeah. I apologize to my learned friend for that. So now, we say that there's room for the court must set that judgment right on 12.1, capital A, 1A.
Mr. Manati, I'm sorry to interrupt you. This relates to where you were a moment ago in paragraph 25.
Yes.
The sixth or seventh line. The rider is added at the end of the sentence. Again, assuming no change in the target's current efficiencies.
Yes.
So the increases specified before that would be based on that assumption.
Yes,
in
but
paragraph 122 of the respondents' heads, it says, in light of the CAC's finding that the Mediclinic is likely to introduce significant efficiencies to the target hospitals, no substantial CPE increase for uninsured patients is likely. So was there an in-depth study or information presented about the targets and the current efficiencies?
The answer, Justice Toron, is at paragraph 113 of the same heads of argument. So it says, there was no evidence before the tribunal in respect of the likely CPE for uninsured patients at the target hospitals post-merger. Self-evidently, the actuarial analysis conducted in respect of CPE for insured patients cannot be conducted on the very small sample of 100 to 200 admissions, which would result in volatile results which could not be relied upon as being representative. So the latest statement you find at 122 is a naked statement. It's simply a bold statement made. But the common cost fact is there was no such an assessment. And so all they're really saying, what the merging parties are truly telling the court is this uninsured patients are up to 200 admissions at the target hospitals per annum. They're a small number. They constitute a small portion of a small market in a small province, in a small town. Forget them with respect, because that is the same approach they adopt in relation to public interest. Other than offering a condition, and we will deal with the condition, other than offering a condition, they have no answer to counter the fact that there is this significant increases at paragraph 25. And if you read the CAC judgment carefully with respect. I know the court will do though, has done so and will do so. But if you look at paragraph 25 and you trace the logic and the reasoning of the CAC up to 213 where it makes the conclusion, and you want to see where does the CAC apply itself to whether there is an offsetting by efficiencies of this significant increase at paragraph 25, you will not find it. So they got lost in that analysis. And if we are not careful, they get lost again because they say they are a small portion. But when we get to public interest, we will submit that that exhortation by the merging parties, which tempted the Competition Appeal Court, is an unconstitutional approach to an assessment which clearly affects a constitutional right, and not just a constitutional right, an important constitutional right. Because in South Africa, the majority of patients who seek who seek healthcare are not covered by medical aid. So to the extent that you can provide protection for the small number that can pay these prices, the Constitution can do no better than to protect them. And so you will not allow a measure of this kind, which says they must be lost in the wash because they are a small number, when Section 27 protects that right to each and every one of us. And that brings me to...
Oh, sorry. Mr. Manager, can you, if I understand your argument correctly, your constitutional argument seems to apply both to interpretation and application. I understand it insofar as it relates to application. Can you please make me understand how exactly it applies to interpretation?
As the court pleases, I'm turning to the section that the court said it actually applies, which is 12(1)(b) and subsection 3, which deals with the public interest consideration. And I just wish, again, just to remind the court what that section says, so that when we look at it, it's important, and when I go to relevant case law is important. What it says is, what it really means, and the CAC has explained, is irrespective of your conclusion on the competition assessment, you then must go to the public interest consideration. And there you're asking two questions. You're asking this question: can the measure, despite your finding upstairs, be justified on public interest considerations or be prohibited on public interest considerations? So you could, for instance, have a measure which lessens competition, but produces so much benefit for the public that you can still allow it, maybe subject to conditions to deal with the competition concerns. On the other hand, you could have a measure which has no competition concerns, but has substantial impacts on the public interest. That can be prohibited under that public interest concern. And just on that, the way the CAC has explained this is that the first inquiry is a rationality inquiry. You want to understand whether the public interest concern flows from the measure. And then on the second, if you find that it does, then you must determine, is it substantial? And then if it's substantial, are they countervailing, in other words, competing public interest considerations that outweigh that consideration, that concern? And they say for that, the merging parties carry an evidentiary burden if they want to rely on a public interest consideration which competes. And they also say that that competing public interest consideration must fall under subsection 3, must be one that falls under subsection 3. Is not the efficiencies claimed for the competition assessment. And that is made clear in a judgment of AMCU, which is Association of Mine Workers, and it might be convenient for me to give you the citation now because I will refer to it. It's Association of Mine Workers and Construction Union and another versus Competition Tribunal of South Africa and others. The neutral citation in brackets is 169/CAC/DEC 18, December 18. And in square brackets is 2019. And then ZACAC in caps, page 1 is a judgment of 17 May 2019. And I asked the court to have regard in that judgment to paragraphs 23, because 23 poses the issue. It tells you that in that appeal, the only issue related to public interest and not to the competition assessment. And then at paragraph 29, it tells you that there's a second leg of the inquiry. It says the second leg of the inquiry emphasizes the public nature of the test. That's the second leg being the public interest. That is, if the merging parties are able to demonstrate that a loss of employment, for example, promoted efficiency and thereby could be justified by a gain to shareholders, this alone cannot be considered to have satisfied the public interest ground for approving the merger. By contrast, a countervailing public interest ground would be one of the other grounds set out in section 12, capital A3, namely the ability of a national industry to compete in international markets, the ability of firms controlled or owned by historically disadvantaged persons to become competitive, or the necessity of saving a failing firm. And then at paragraph 44, which I asked the court to also look at, the judgment says this inquiry, the justification inquiry, that is now the competing interest. 44, this inquiry requires the merging parties to show that the public interest in preventing employment loss is balanced by an equally weighty and countervailing public interest which justifies the loss and which is cognizable under the Act. In turn, this inquiry requires an examination of the proper counterfactual, that is the position absent the merger. Can I just illustrate how the case in this case departs from what I just read? Is that at paragraph 128, it says this, now recall it has decided that this is not a competition assessment, it's only a public interest. It says at paragraph 128, the fact that price effects must in the present case be assessed in the context of public interest rather than SLC has an important effect on the evidence dealing with the relative efficiencies of the targets and Mediclinic. Where it is shown that a merger is likely to substantially prevent or lessen competition in a relevant market, it is for the merging parties to establish that the merger is likely to result in technological efficiency or other pro-competitive gains, which will be greater than and will offset the effects of any prevention or lessening of competition. Then it says, because no SLC has been shown in the present case, in other words, in the sense that I've debated with the court earlier, the merging parties do not attract this onus. There's the first point. They don't attract any burden. In the context of public interest, we are trying to ascertain what prices are likely to prevail at the targets if the merger is allowed, and whether assuming such prices to be higher than they would otherwise have been, this is a sufficient basis to prohibit the merger on public interest grounds. The efficiencies which were the subject of factual and actuarial evidence are simply part of this predictive exercise. So he does two things in that. He says they don't have an evidential burden, and he says the efficiency claims are relevant to counter the public interest consideration. I just read the Amku judgment, which says you can't use efficiency gains. So he says this is not a competition assessment, but when he goes into the public interest assessment, he borrows the competition assessment kind of process, which is another misdirection. So those two are points of law, of course, the onus and the evidentiary burden and what can be raised as justification. The next important point, which we say is the most substantial of the
I'm sorry,
points
Mr.
of law.
Manechi, before you move on, can I just ask you about the efficiency gains in respect of the uninsured market? And just for clarification, please, if you look at paragraph 69 of the CAC judgment.
Yes.
They're dealing there with the uninsured market.
Yes.
The patient's overall bill will be affected by efficiencies in the management of theatre and war times and in the acquisition and use of surgicals and ethicals.
Yes, he does. He refers to that, yes. But as you know, none of that was quantified for uninsured patients. So he's again launching on speculative reasoning where there is no evidence of any efficiencies quantified in relation to uninsured patients. he's going to conclude that even that there will be no price increase for uninsured patients when paragraph 25 remains, even if the court were to take a more generous approach and credit the merging parties for the 6% calculated as efficiencies to be gained. It does nothing to the number that is at 25, paragraph 25. It still leaves a double-digit increase. So on any account, whether you give them any credit for uninsured patients, you're left with a significant increase. But in fact, the merging parties are very candid to tell this court that no quantification was done. Where else can the CAC derive any quantification for efficiencies to offset the significant clear price increase at paragraph 25? So that's our submission. There's just no basis. And it's been our criticism that the judgment embarked a lot of own reasoning and own speculation, as if it was a court of first instance. And this also illustrates that very clearly. The tribunal and the merging parties all agree, no quantification. The dissenting judgment, no quantification. But somehow the majority finds that there will be some offsetting. That can be. So can I, against that backdrop, just deal with what we submit it's an important question of constitutional law here is, in Makate, this court emphasized, as it has done in many cases previously, that all courts have an obligation when they're dealing with a provision where there is an interpretation may affect a constitutional right, that they must adopt an interpretation which better promotes the right. And they must do so whether litigants ask them to do so or not. And so a failure to do so with respect is a constitutional issue on its own. In this case, how we submit the court should have adopted a meaning of section 12 capital A 1B on substantiality in relation to public interest was to ask whether, if you have this significant price increase, where the court itself acknowledges that these uninsured patients are vulnerable, and it says that at paragraphs 136 to 140 of its judgment, they are a vulnerable group. Once you conclude that and you look at the substantial nature of the increase in the bill for an uninsured patients, taking a constitutional approach, one would take the interpretation in NetStar that if the effect is not trivial or speculative, it is substantial within the meaning of section 12 capital A. But it doesn't do so. It just doesn't tell us even how it evaluated the question of substantiality. And the reason we submitted made that error is once it paid lip service to section 27 and to the fact that these are vulnerable groups, it ignored its obligation under 39.2, although this was submitted to the court in the appeal hearing, that it is important not just to have regard to the fact that this is section 27, but 39.2 urges you to adopt not just an interpretation consistent with the Constitution, but an interpretation that better promotes. Now, this interpretation does not better promote. In fact, it negatively affects the right of access to healthcare for uninsured patients in that market that this court has defined. And we will submit that that effect doesn't change with the condition that they impose. Maybe let me just telescope that point because I'm here. So they say to deal with, so the cake really makes a judgment call which is quite difficult to follow at page 213. And I'll explain why we say it is difficult to follow. At 213, it's in volume 36, at paragraph 213. The cake concludes in this way. It's at page 3561 of volume 36. See, it says, since the tribunal's factual findings on SLC and public interest cannot be sustained, we are at large to consider whether approval of the measure should be conditional or unconditional. By that, we understand that it has rejected the tribunal's conclusion that there will be an SLC, lessening of competition, and that there will be a serious public interest concern, a substantial public interest concern. But then it says, because I find no SLC, the question is whether the possibility of a slightly increased CPE at the targets during the grace period calls for a condition. So it opens the door for it to impose a condition, even though it has concluded that there is no SLC. Now, we have referred the court to the judgment of Justice Rogers in Emery's. We've referred to it a number of times. I asked the court to look at paragraph 37 of that judgment. You will find there that what the court said is that if the tribunal reaches a conclusion that there is no SLC and there is no public interest consideration, it would be bound to approve the merger, and said otherwise any other decision would not be rational, It says so. But what has it done in 2 and 3 is it reaches a conclusion, there is no SLC, there's no public interest concern, and then adopts what it says is an irrational approach of imposing a condition. The merging parties try to justify that by saying, well, we tendered the conditions, this is all out of extra caution. But we submit that's not the real reason in 2 and 3. The real reason here is, although this judgment appears to suggest that the court made this conclusion, there was a concern still that there may still be an increase in CPE, and that is why you see the conditions coming in. But it had to make the conclusion in the first sentence because it needed to say it is at large to consider the matter afresh. Because if it had accepted the findings of the tribunal, but wanted to reverse the decision on conditions, then it would have to meet the higher threshold to show that there was a misdirection by the tribunal in relation to the conditions, as this court said in Mwelasi. Because in Emery's also, the same court, the same judge who wrote the judgment for this court said the tribunal's choice of whether to approve or approve subject to conditions or prohibit is in the nature of a remedial discretion. And interference with that discretion requires either, if it's a true discretion, to show that they didn't exercise their discretion judicially, or if it's a lower discretion, still to show a level of deference to the tribunal. But here he wanted to open the gates widely and not be constrained by that consideration. And that's why he concludes in the way he does. But let's assume that I've persuaded the court thus far that for uninsured patients, there's either an SLC or there's a substantial public interest concern. And he says you can cure it with a condition, which is a condition that the merged entity will continue to apply the discount policy of the target firms for a period of 5 years. Now, the immediate problem that you find is that everybody accepts that this market has high barriers to entry. So you are unlikely to have entry of another hospital in Klerksdorp, which is going to increase price competition and drive prices down. So the likelihood is that if the condition only survives for 5 years, when the 5 years end, the private patients, uninsured patients, go back to the high prices. That's the first problem. The second problem is the merging parties say, well, Mr. Bayes said they're going to change their pricing from a fee for service to a fixed fee, and so that should be taken into account. But in these volumes of evidence, no evidence was presented whatsoever by Mr. Bayes to show how that pricing policy that changes from a fee for service to a fixed fee would impact on the higher tariffs for uninsured patients and the higher CPE that they're going to experience, and whether those discounts will be lower and comparable to the target hospitals. That's the third problem. Sorry, the second problem. The third problem is, you'll recall that in the policy, as the judge explains at paragraph 25, the policy of the target hospitals is that the range of discounts from the lower number to the double-digit number is at the discretion of management. Now, if you give a condition that doesn't fix that range, you leave it to management, nothing stops Mediclinic from choosing anything in that range, which is closer to the lower end as opposed to the higher end, and justify it on commercial considerations. The emerging parties offer yet another answer. They say, well, this court must now make that condition perpetual. With respect, if they wanted to tender a perpetual condition, the place to do so was at the tribunal. At the tribunal, they rejected that there was a need for a perpetual condition, because if there was, then one would have canvassed that with the medical schemes, with the commission to see whether it could work. But the commission says, even in relation to 5 years, which the tribunal accepted, you will see that the reports, the multitudes of reports you have in here, which analyze efficiency by actuarial calculations, are complex, but there is no agreement on methodology amongst all of these people who say they know better what to do. No agreement. So the commission says, well, we don't have auditors, we don't have actuaries in our employ. If we are to monitor this for 5 years, we have to employ those people, let alone that condition is not effective. Now, when you make it perpetual, the burden on the commission is greater. But what is the loss for the merging parties if you simply prohibit the merger? The same judge in Emery's gives you the answer in paragraph 40. He says at paragraph 14, it's worthwhile reading what he says at that paragraph. We quote it in our heads because it gives you a good answer. So if the tribunal is at a point where it says there is a substantial public interest consideration, you've offered me a condition, I'm not sure that this condition is going to cure the problem. What rational decision can they make? Justice Rogers says at paragraph 40, he says of Emery's, where in the situation just mentioned, the tribunal is asked to approve the merger with conditions rather than to prohibit it, the choice of remedies is in the nature of a discretion. I've already covered that. I reject the proposition that the commission bears the burden of proving that the proposed conditions will not adequately address the likely SLC. The tribunal has the power to prohibit the merger if it is not satisfied that the conditions will adequately remedy the likely SLC. And regardless of where the onus lies in respect of proposed conditions, if it is, and in brackets, if it is accurate to speak of onus at all, I do not think that the tribunal is obliged to approve a merger just because it finds it more probable than not that the conditions will neutralize the likely SLC. One should bear in mind in this regard, the real problem in such cases will not necessarily be competing views as to the probable future state of the market, as in here, the barriers are high, but an inability to make reliable predictions at all, especially as to duration. I think this is the important part. I think it is permissible for the tribunal to reason thus. The merger will likely give rise to an SLC. Although the proposed conditions are more likely than not to remedy the likely SLC, there is a reasonable possibility that they will fail to do so. Therefore, we prohibit the merger. He says that's perfectly rational. And he explains why he says so. He says in paragraph 41, particularly where the uncertainty about the adequacy of the conditions concerns the likely duration of the SLC rather than the nature and content of the SLC, prohibition has this advantage over conditional approval. It does not necessarily represent the final word. If the merger is conditionally approved and the conditions turn out to be inadequate to neutralize the SLC, the harm cannot be reversed. If, on the other hand, the merger is prohibited and with the passing of time, it becomes clear that the merger will no longer give rise to SLC, the transaction can be renewed. And this has been the experience of the tribunal, that it has in a matter involving Telkom and BCX, where Telkom wanted to buy BCX to extend its offerings, at a point in time when Telkom enjoyed a monopoly in telecommunications, said, no, this merger will be anti-competitive. And then when matters changed, circumstances changed more recently, about 3-4 years ago, counting from 2007, when conditions changed and Telkom was facing competition, Telkom was allowed to buy BCX because the conditions no longer prevail. But had it allowed the merger in 2007, the market might never have become competitive. So that's what Justice Rogers says here. and he concludes that that is an appropriate one decision to make. But if you go back to 213, where he says there is no SLC, but I'm worried that there may still be a pricing increase. And he still differs with the tribunal saying we are concerned that the condition may not adequately address that SLC or public interest concern, and we don't approve the measure. He disagrees with them, but he said he commended this approach to them previously. And the tribunal followed this. If you read the tribunal decision as you've done, Justices, they copy this judgment repeatedly because it's the guiding book. And then he departs from the precedent, he said. So with great respect, there are significant issues of law and constitutional issues here, just by reference to the approach I have submitted in relation to the uninsured patients. And it's really, we submit beggars belief that the court could conclude in light of section 39(2) and 27 of the Constitution, that given this pricing effects, there is no substantial public interest to prohibit a measure which can be renewed 5 years down the line. So against that, the next topic is the insured patients. The legal points I've raised in relation to uninsured apply with equal force. So the interpretation of section 12A1A applies equally. The approach to the issue of public interest under section 12, capital A, sub 3 apply equally. And again, even in relation to that weighing of the public interest concern against the efficiencies, he also departed from the AMCU judgment and preferred an interpretation that you can weigh them, you can weigh efficiencies against public interest. So, and
Sorry,
we've,
Mr. Manager. I'm sorry.
that's cool.
I had your argument to be directing the application of section 39(2) of the Constitution to the concept of public interest. Now, I just want to clarify whether the same approach should extend to the interpretation of the first part of 12A, which relates to the substantial lessening of competition. Does the right of access to healthcare play any role in that interpretation? Remember the question of whether or not it is substantial from the point of view of the service provider. The service provider says the number of uninsured patients is very low, so it's not substantial. So I want to get clarity whether in determining the meaning of substantial lessening of competition, do we have to invoke section 39(2), read with the right of access to healthcare, in view of the fact that also here we're dealing with private parties, not the state?
Well, we submit yes, because the importance of the market is relevant to that inquiry also. And also that although we are dealing with private parties, our criticism focuses more on the obligation of the court. So it's the court interpreting, and it's the court's duty to have regard to 39(2). And in that context, the approach to what is substantial would be affected by the importance of the service or the good, in light also of the purposes of the Competition Act, which says the act is there to promote choice and to provide for cheaper services and goods. So it is absolutely relevant. And we have submitted also that even in that context, the notion of substantial must follow the approach adopted in the Netstar judgment, because if one takes that approach, then one can't conclude that a pricing increase of this kind under the competition assessment is not substantial. So we submit that it remains relevant to 12.1a. And the criticism we received from our learned friends is that we don't suggest in what interpretation should have been adopted which better promotes that right. And we say first is to interpret 12.1a in light of the purposes of the Act, which directly promote the right of access to healthcare under 27. And the Act tells you that it's the effect of the measure that you look at. You don't adopt an interpretation which requires a change in market structure, which defeats that the purpose of the Act and the right of access to healthcare, which is what this interpretation ultimately does. So we submit that the importance of the market will always be relevant to the assessment, both under competition and under the public interest consideration. Because in our case, in our legislation, under the purpose of the Act, the legislature has made it clear that it's consumer welfare which is important. So we're not just looking at competition, maintaining competition for the sake of it. Is to maintain competition to produce the good, which is consumer welfare. And that is achieved when there is choice and cheaper prices. So we would submit, Justice Jafta, that the court, that is still relevant. But we do accept that the court, with the public interest, it's just so obviously relevant that no court should be blindsided, but we're not suggesting that it's not relevant on the other interpretation.
Mr. Mandechi, I just want to check with you before you finish off. Are you going to deal with the procurement exemption aspect and more particularly the extension thereof? Because there seems to be an objection to you introducing that evidence at this stage.
Yes, yes. In fact, I'm turning to the insured patients, and I was just saying to the court, I don't wish to repeat the arguments on the interpretation of both sections, the competition question and the public interest question, because we say the same thing. What we do say is that even in relation to the insured patients, there were findings the tribunal made which were not disturbed, which showed that there would be an impact on, well, one is contested and one is not really, we don't understand what the case says about it. And that is a finding you will find at the tribunal, in the tribunal's judgment at paragraph 170. If the court, and that is in volume 34 at page 3372. And so the tribunal is dealing with the pricing increase. And this is, just to be clear, is not just the tariff increase, is the efficiency adjusted price increase. And it says, in the absence of any efficiency gains, a measure of two firms under the same ownership and management implies that their pricing decisions will be coordinated to maximize the total profit. This implies that prices will increase post-merger. So that's the impact, that's the effect following upon the implementation of the merger, because even the target firms will now acquire market power, which they otherwise did not have previously, where they did not have the market power to charge high tariffs. But now they, by effect of the merger, they now gain market power, which, and once you put them together, their incentives change, and their incentives will be to maximize the total profit. And that total profit means increase in the prices. And that is a competition effect. A second competition effect is one that is identified in the minority judgment. And you will find that at paragraphs 244 to 246 in volume 36, it's page 3577 to 3578. And that is to say that even in the local market in Potchefstroom, the merger would have an effect on the competitive process that takes place between Moimed and Mediclinic Potchefstroom. And and the court can have regard to what the minority says there, which is very much approving what the tribunal had found. And what the CAC did with this was to dismiss it as a protection of a competitor and said we must remind ourselves that the Competition Act is not intended to protect competitors, but the competitive process. But what the finding here relates to is how the impact on Moimet would impact on how it is able to compete with Mediclinic, which is a competitive process which will maximize consumer welfare. So even in relation to insured patients, there is an effect on competition which does not involve a change in market structure. And because the court adopted a change in market structure, it threw that out and also said this is to protect competitors and not competition. So we submit that when you look at 213, where the CAC in fact says there's still going to be some increase in CPE, although it says a marginal increase during the grace period, that must proceed from the premise that there is going to be an increase in CPE, but it's going to be slight because it will only apply to the grace period, and that's what Justice Majid is asking me. So the question that Justice Majid is asking relates to, sorry, if I can just put my file back, relates to the efficiencies that the merging parties claimed. Now, during the course of the hearing before the tribunal, and the transcript bears that out, the merging parties repeatedly put to all witnesses for the commission that if the merger is implemented, they're going to deploy procurement efficiencies in the procurement of surgicals to the target hospitals, and that will offset the CP increase as a result of the tariff difference. So what is said at paragraph 24? Recall that paragraph 24 says there's a percentage difference in tariffs between the target hospitals and Mediclinic. This translates into a CPE increase of 8%. And now they were saying, well, we are bringing procurement efficiencies which will be immediate, and those will cancel out the CP increase as a result of the tariff differences. And they could say that because, and they've emphasized that, they said we are large in size, so we can bring economies of scale and therefore can negotiate better pricing with suppliers. And as a result, the day we take over the target hospitals, which are small in size and can't have the same procurement efficiencies, we're going to realize a big saving, which will cancel out the pricing increase as a result of the tariff. And therefore, there will be no negative CP impact on the target hospitals. In other words, there'll be no increase in the CPE on the target hospitals. That's what they were saying. They retained that argument, and the responses from the commission's witnesses, Mrs. Van Rienen and Dr. Conradi, was Ms. Van Rienen saying, but even in Moimet, I can play suppliers against each other and get better pricing. You don't only have to rely on size. And then Dr. Conradi said, we've also applied to the commission to extend our existing exemption to collectively bargain with medical schemes to include our ability to procure centrally. And now that would change. If it was granted, it would match and exceed the size of Mediclinic, because it's common cause that in size, the NHN network is larger than Mediclinic. So if they were procuring centrally, and the target hospitals benefited from that central procurement, then that offsetting effect will be lost. And so you will still be left with the increase in CPE of the number that is given at paragraph 24 for insured patients. The further answer from the merging parties, which you've seen in the reasons, was that, well, you won't be able to realize those efficiencies immediately because you don't qualify in terms of the criteria for the exemption. You're not a small and medium enterprise, owned by historically disadvantaged individuals. And then we said, but there's a 2-year grace period to allow them to get there. And they said, well, they are likely to get there. The CAC said, well, they can. There was an HDI offer during the bidding process for the target hospitals, LandMed, and another offer. But so says the CAC, it's unlikely that the target hospitals will take that lower price instead of the Mediclinic price. And we say, but there's an incentive. If they're going to benefit procurement efficiencies, there's an incentive for them to try to comply. And then they had another argument, but they don't coordinate their desperate hospitals because they're just a network. They're not like Mediclinic, which has common requirements and can procure more efficiently than NHN. But the answer was, well, that's no answer. Because if you look at the Mediclinic group of hospitals, about 55 of them, their procurement, their efficiencies, their CP efficiencies is so varied. It's different, even though they are claiming that they're procuring efficiently as a group. You have some that are less efficient than others. So that is not an answer. And then they now say, so they still maintain that, and it's in that context, the tribunal accepted the commission's argument that the likelihood is that in the grace period, and if they come to comply with the exemption procurement, they will be able to realize the same procurement efficiencies. There is no factual basis to deny that they will not be able to do so. And the merging parties insisted that even if they did, they'll only achieve half of those efficiencies. And that's the argument they made to the CAC, and the CAC accepted that argument, that they will only achieve half of the efficiencies that Mediclinic is able to achieve. And as a result, the CAC could say, even if there's a CP increase, it will be marginal because they won't get the full efficiencies. Now, we submit with respect that the CAC's findings on that is really in the realm of speculation. There is nothing to suggest that it is not plausible that a qualifying bidder might come across and purchase these target hospitals, and that they may enjoy the procurement efficiencies, and that with those efficiencies may be able to give cheaper prices, whereas if you allow the measure, the prices may go up. Now, the only reason we introduced the letter is to show that the grace period has been extended. You'll recall that there's a guillotine in the notice of exemption, that if you don't qualify within 2 years, you are excluded from the procurement exemption. And all we're doing is to place a letter, a formal letter by the commission saying the grace period is extended to October 2021. You'll accept, Chief Justice and Justice of the Court, that whereas the merging parties still hope that this court will allow them the merger, they are never going to try to say that they can benefit from the procurement exemption. So the affidavit which they are trying to introduce is to that effect, that we haven't benefited, we are pursuing this merger. Well, they are saying so because to say the opposite would mean you must uphold our appeal. But the real point about this is that we submit that there was no basis. If one reads the Emery's judgment, also following on those paragraphs that are referred to, 41, 42 going forward, you will see that in that judgment, the CAC says, although the tribunal and the CAC are both specialist courts, the tribunal is required to have economists, and there was an economist in this panel who wrote the judgment. They say, because they are required to have economists, whereas the court is drawn from the ranks of the High Court. Granted, they deal with competition matters repeatedly, but one can't say by qualification they enjoy any more expertise. So what Justice Rogers says in that judgment is to say that even where you're not dealing with the exercise of discretion, but you're dealing with the probabilistic or predictive judgment of the competition tribunal, the court must tread with deference to the findings made by the competition tribunal. And we submit with respect, this is almost consistent with the deference generally by appeal courts to the trier of fact. But here, he says so in a different judgment. He says so in the paragraphs. Just after 41, if the court reads, when the court reads further, you'll see all that makes very, very clear. But in this case, whereas both the tribunal and us in the appeal refer to this judgment, it is absent by reference in his judgment. If there is a reference, I beg the court's pardon, but my recollection is there is no judgment. There's no reference, but that judgment is key to what the court was doing, because the court was second guessing the tribunal and saying, you got certain things wrong, even as to how negotiations take place. In my view, this is not how it would take place. That kind of reasoning that one would not expect of an appeal court dealing with the judgment of a tribunal, which it has in its own judgment recognized that there's a level of deference to be accorded to that tribunal. And with respect, this court has seen many tribunal judgments. I would submit that this ranks as one of those that the tribunal grappled with every issue that was raised, all the facts that were relevant. And we would submit, as obviously we should, that it was a properly reasoned judgment. And so when the minority said in each instance, on this issue, I find no misdirection. On this issue, I find no misdirection. One will struggle to find misdirections in the CAC judgment of the tribunal judgment. In fact, that wording is not used, that there is a misdirection. Instead, it is, I don't accept that logic, or this is unlikely to be so, this is not plausible, that is plausible. With respect, so we submit that that's a wrong approach. The other issue that's relevant to this issue of insured patients, of course, is not just the grace period, is the actuarial calculations and the fact that the tribunal found them to be unhelpful. So the tribunal,
while you are there, just so we know where you are, I realize that my colleagues can't be the reason for you taking long. They are not engaging you that much. How much more time do you need?
I think I should, with the indulgence of the court, maybe just take the next 15 minutes and wrap up everything. Or perhaps 10 minutes. Let me not say 10 to 15 minutes. I'll wrap up. I'll definitely wrap up there. So if I can turn to the actuarial calculation. So the difference in approach between the CAC and the tribunal is the tribunal says we are required by the Competition Act to conduct a predictive judgment on what is the likely future conduct of the parties in the market in relation to price, in relation to other forms of competition. And the actuarial calculations, which you will see there are many iterations of those reports. I mean, there are many of those. And even after the very last one, even after the court hearing at the CAC, you will see at paragraph 201 and 202, the CAC still asked questions for the merging parties to clarify, because they are just inconsistent logical conclusions you would think would flow, but don't flow from those calculations. But this is the point. So the tribunal said, as an expert, you must assist us in discharging our obligation to predict future conduct. These actuarial calculations are backward looking. They are not telling us what the likely competitive effect is going to be in the market. What will, if competition changes, where will prices land? This don't tell us anything. You're telling me all about the current situation, but of course you need to know the current to predict the future, but you can't even tell me what the likely future is going to be. And in our heads, we reproduce what the actuarials accepted, that they can't help predict in that predictive judgment. So that's the first point. The second point is that even though they suggest that overall, once Mediclinic takes over these target hospitals, efficiencies are going to increase. The tribunal noted that it was common cause that there is a high degree of variance in efficiencies between the group hospitals themselves. So how could you say with confidence this is likely? The third point was, and for example, if you looked at Potchefstroom, Mediclinic Potchefstroom, the medical scheme said it was less efficient than the target hospitals. But the criticism was you can't use one hospital to compare to the target hospitals. You must select a group of 7. But what did Mr. Charles do? He selected a group of 7, which were amongst the most efficient within Mediclinic, to compare them against the target hospitals. So the tribunal said, but even that selection is not informed by competition dynamics, so it's irrelevant to the inquiry we have to conduct. The next problem was that all the factual witnesses agreed that except for the procurement efficiencies, the other efficiencies depended on doctor behavior and hospital management. You recall the efficiencies about whether you're going to use generics or originals, whether you're going to select the most cost-efficient surgicals when you do operations in the theater. But that depends on the doctor. Is the doctor going to go along with the objective to prescribe generics or to be more efficient? And all of them agreed that this takes time. It takes time to change doctor behavior. So you can't say, after we take over this target hospitals, we'll change doctor behavior immediately. And it's important because efficiencies must be timely. Otherwise, the anti-competitive effect will last for a period of time. So you can't, if it takes you a year to turn the situation around, that's not good enough. And then some of those efficiencies were not major specific, like the choice of generics. The reason the target hospitals were using originals and increasing their CPE, in other words, their inefficiency, was because the manager, who is going to be remain the manager of these target hospitals, gave the doctors more leeway. He gave them more freedom to choose. So they chose what they wanted. Now, how is this manager going to change immediately tomorrow because there is a new boss in town? That will take time, and that was accepted. The other consideration was Dr. Smart, who is the boffin who does all the calculations and all of that, made it very clear, and we summarized this in our heads, that for you to deploy the efficient systems for Mediclinic in the target hospitals, you need to have matchable data in the target hospital. So they must have data which is matchable to their system and can be rolled out. And he said, we don't know whether the target hospitals have that matchable data because the due diligence that we've conducted was not that insightful. But then on the other hand, Mr. Steenkamp, who's the hospital manager, made it very clear that we don't have that matchable data because we don't keep the same kind of data that Mediclinic keeps. So there's going to be time before those systems take foot. So, but what the CAC does with all of this actuarial calculations to say, well, first they say, Alexander Forbes had a student actuary and Mr. Charles is very experienced. And so there's no reason to be doubtful about the fact that when they say that Mediclinic is going to be more efficient, they mean it, we must accept it. But with respect, there is no magic in it because the existing variance in efficiency in the hospital group Mediclinic already tells you that it's possible that some may sit at a lower percentile of efficiency than others. And there is no magic that this target hospital will sit in the better position than in the lower section, if I could put it like that. And the minority judgment deals with that and highlights the point that expert evidence must be relevant to the issue that the tribunal must decide. And we referred to the Sasol judgment of the CAC itself, which criticized experts who overreach and give evidence for which they are not qualified, which is not assisting of the inquiry. And we've cited that. And that was not heeded. So that's our point on uninsured patients, that the same consequence should flow, that there was an SLC, likely SLC, there was a substantial public interest, and the pricing remedy doesn't cure that. It's time limited. Here's the irony, is that the merging parties throughout the tribunal said, we're going to call Discovery Health to give evidence. They will come and show you that Mediclinic is more efficient than the target hospitals, and they have expressed no concerns with the merger. When they proposed the last conditions and the tribunal asked for further comments from medical schemes, Discovery Health said it had concerns with this and said the discount should at least be about 7% as a condition, and this duration is limited, and Mediclinic for inexplicable reasons was never called to testify by the merging parties. We don't draw any inference, we're simply making it known that the tribunal also remarks on that in its judgment. So that's our submission. So we conclude that on the price effects, and it's important to emphasize the price effects do not turn on market definition. So the court doesn't have to engage with the facts about what is the right geographic market or not. Can accept the narrow markets, they are pricing effects and they are substantial public interest considerations. And another error, misdirection, was for the court to conclude that it was at large and ignore the Mwalase standard for interference with the remedial discretion, and its own previous judgment that there is deference to be paid to the tribunal. The last point, I refer the court simply to the heads of argument in our application for leave to appeal, and that is the impact on bargaining within the market that is defined by the commission. And the court will find that discussion brief at paragraph 44 of our heads, sorry, page 44, paragraph 153, and we refer to the founding affidavit in the application for leave to appeal. That is the argument we make, that the CAC was wrong in interfering with that finding also of the tribunal. It should have showed some deference. So in summary, on all of what we submitted, we say there is jurisdiction. This case engages directly the constitutional approach of courts, 39(2), and a constitutional right, and also the powers of the tribunal in relation to the competition assessment, and not saying you can't be in competition, you're only in public interest because there is no market structure change. We also say it raises a number of arguable points of law, which I've addressed. And our learned friends raised the issue about we should have gone to the CAC and we should have gone to the SCA, but all of those have now been sorted out with the amendment to the Competition Act in section 62(4) and 63 that we now only apply to this court for leave to appeal. So we submit, and just in addition, the Media 24 supports the fact that leave to appeal should be granted. It's in the interest of justice to grant leave because you have differences between the tribunal, the CAC minority and the CAC majority. But we point out that you also have the HMI report, which you'll find in volume 37 at page 3743 at paragraph 121. At that paragraph, it's after talking about high costs of healthcare, major creep and all of that, commends the tribunal for this decision. And so there's another party that says we submit adds to the public interest, to the interest of justice in granting leave to appeal. So we would submit that leave to appeal should be granted and the appeal should be upheld, and the CAC order should be replaced with an order dismissing that appeal to the Competition Appeal Court. Those are our submissions. Chief Justice and Justices, I'm really grateful for the indulgence, as the court pleases.
Thank you, Mr. Manager. Colleagues, I'm just wondering if a break is desired or whether we should perhaps just proceed.
Minutes, Chief Justice.
How long do you propose, my sister?
5 minutes is also fine.
Let's make it 15.
Thank you, Chief Justice.
Court will adjourn for 15 minutes.
Court will adjourn until 12:10. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 12:10. Should you exit, you may use the same link to rejoin the hearing.
Court pleases.
Are we all back? Justice Strong?
Chief Justice, I'm just checking. Justice Kampepe, Justice Majid, Justice Pillay, are you with us? Justice Majid? Mhm. Chief Justice, I think we may proceed. I will check with Justice Majid.
We probably still have a few minutes. I don't know. Maybe just wait for him, please. Is he still not connected yet?
Not yet, Chief Justice.
Well, then I think we should proceed.
Chief Justice and Justices, all counsel are online.
Mr. Butler?
Thank you, Chief Justice, Justices. As we understand the focus and structure of the submissions for the Commission, they have dealt in the time available with three main topics. The one being the question of uninsured, particularly in relation to the public interest issue. The second being the interpretive aspect under Section 12A. And third, the question of price effects, including in relation to scheme price effects. We will in due course seek to demonstrate to you that none of these issues properly interpreted trigger this court's jurisdiction. All turn ultimately on questions of fact or inferences of fact. In the submissions that follow, Justices, I will deal with certain main topics up front, and then with scheme price effects, including the procurement issue and the uninsured. My learned friend, Mr. Mbikiwa, will address you thereafter on aspects relating to this court's jurisdiction and the invocation by the Commission of what it argues are the triggers for this court's jurisdiction. If I may briefly outline from the large number of facts that the record in this matter discloses, certain main points which we submit are common cause. This merger, as you know, involves the proposed acquisition by Mediclinic of 2 hospitals in the Northwest Province, and in particular in the market of Klerksdorp, in which Mediclinic currently has no hospital. It has no hospital in Klerksdorp. Mediclinic has the lowest market share in the particular market of any of the groupings. The NHN is the largest of the groupings. Mediclinic's market share would increase by less than 1% in the relevant market. The NHNs would reduce by less than 1%. The question of concentration of that market raises no concerns. This was dealt with in the report of the economist for the merger parties, and we've provided it to you, Justices, at page 16, footnote 43 of our heads. That is a further uncontroversial fact. Justices, the NHN group was the subject of substantial evidence as to its own efficiencies and inefficiencies, and that evidence is before you. Because it is confidential, I won't refer you to the exact numbers, but the essence of that evidence, the uncontested evidence, you will see in the evidence of the representative of the NHN, particularly in volume 20, page 1966, 1984, and 1988. That is all uncontroversial. I'll come back to this later, but that was also a comment made by Discovery, which became common cause during the evidence on which Discovery did not need to be called to testify. As a result of this merger, it's also common cause, Mediclinic will be able to implement and will implement advanced efficiency and procurement and quality systems that it applies across all of its hospitals and which it has derived from national and international standards and measures. That is uncontroversial. It is also uncontroversial, Justices, that there would be no adverse impact on employment or small businesses or firms controlled by historically disadvantaged persons. The minority shareholder in this matter has resolved to disinvest, selling its shares to what it considers to be its maximum advantage. None of the main concerns raised by the HMI report are implicated because this does not concern a creeping merger, and there is in fact going to be a decrease in concentration nationally as a result of this merger. There will be no concentration increase in Klerksdorp. And then the last matter of general observation, Justices, is that of the 27 stakeholders who furnished comments, 21 do not oppose this merger. Those stakeholders include medical schemes. The Competition Appeal Court, as you know, made certain core findings. I'll just list them briefly. The first related to the actual market, the provision of private multidisciplinary acute inpatient services, excluding day cases. That's common cause. The geographic market is defined as the market for Klerksdorp. That was a finding of fact. The merger, it reasoned, would not give rise to any SLC, a finding of fact. It reasoned that there are no substantial public interest grounds for prohibiting the merger. We'll come back to that, also a finding of fact. Fifth, the CAC gave particular and careful attention to issues relating to public interest, to the constitutional considerations at stake, including those affecting uninsured patients and insured patients, and it approved the merger. And sixth, it did so subject to conditions that it considered would be appropriate. It noted that the conditions would have advantages for schemes and for uninsured patients, which they would not have enjoyed without the merger. Those are the, as we have them, the building blocks and the cornerstones of the findings and reasoning of the CAC. The Commission has raised in its application for leave to appeal to this court various matters, some of which were not addressed by my learned friend, of course, given the limitations of time. but some of which have not had any particular emphasis in the heads of argument either. The ones on which we understand there to be no particular emphasis, either in submissions to you or in the heads, are the geographic market, the scheme networks effect, and the patient experience issues. And for the efficiency of argument before you today, we will not address those specifically, although we will give you the passages in case they are relevant to you in the heads and the CAC judgment. Departing then in relation to the core issues that are before you today, we begin with what we submit is a departure point that this court should adopt, and that is, how does it approach findings of fact made by the CAC? The Commission in its heads of argument have urged you to approach this matter on the basis of the judgment in Shembe versus Shembe, and in their heads of argument at paragraph 10 for the Commission, the submission is made that the factual findings of a trial court bind the appeal court unless it can be shown that they are vitiated by material misdirection. We will submit in due course that there are numerous material misdirections that the CAC found with justification, with respect obviously, in the judgment in the decision of the Competition Tribunal. But we submit more fundamentally, what is of importance is the balanced approach that this court has advocated in relation to deference on appeal in its two judgments of Burnett versus Absa Bank and more recently McCarthy versus Vodacom. In those matters, this court recognized that the principle of non-interference should not be overstated, and that if it emerges from the record that the trial court or the tribunal of first instance misdirected itself on the facts or came to a wrong conclusion, the appellate court is duty-bound to overrule the lower court or tribunal. That, we submit, is the balanced approach that you should adopt to the question of deference. Moving then to the interpretive aspect that our learned friends have dealt with in their submissions to you, essentially in the second part of their argument and relating to the structure of section 12A1 of the Act. We make certain preliminary observations which we submit are axiomatic. The primary inquiry under the first provision, section 12A1A, is entirely a competition analysis-based approach. That inquiry must be read with subsection 2, which requires one to take certain factors into account. But the inquiry there is entirely into the likelihood of the merger substantially preventing or lessening competition. It is a competition-based inquiry. For now, and we'll come back to this later, the question is defined by the word likely, and of course Justice Rogers commented on that word, and likely in the approach of the court in Medicross can involve an inquiry of reasonable possibility. Under this first part of the inquiry, as we've seen, if there is a likely substantial lessening of competition, then the further inquiry is whether the merger can nonetheless be justified on the two grounds, one being the pro-technical or competitive angle, and the other being the public interest angle. If there is no SLC, then one does the straightforward public interest inquiry under 12A1B, which must obviously be read with sub 3. There, the expression is again qualified by the word substantial. Our learned friend stressed to you words used by the CAC by Mr. Justice Wallace in NetStar, not in relation to section 12, but in relation to section 4. With respect to our learned friend's argument, that is not a helpful guide. The helpful guide, Justices, is the CAC's judgment in Medicross, which held in relation to section 12 that substantially means materially or considerably in amount or duration. We've given you the references, Justices, in paragraph 26 of our heads. Then, Justices, just on the scheme of section 12, we submit that there are these corollaries. I'll just state them briefly. First, the inquiry into an SLC is determined by the application of competition analysis. Second, the qualifying expressions of likelihood and substantiality are themselves matters of fact. The underlying facts are matters of fact, and the questions as to whether those reach the threshold of likelihood and substantiality are themselves matters of fact. No trigger of any higher jurisdiction occurs unless those are met, and they must be met on the evidence. And the third corollary is that even if there is not a likely SLC or SPI, substantial public interest, for prohibiting the merger, it may still be competent to impose conditions to address any concerns that remain. Justices, in this matter, as we know, the CAC concluded that there were no substantial public interest grounds for prohibiting the merger, but stressed that this did not mean that no conditions should be imposed, and it imposed the conditions as you have seen in Annexure X to the CAC's judgment. That approach was in line with the Walmart merger, which we refer to at paragraph 35 of our heads of argument, and those result in the factual assessment of the CAC in substantial benefits for insured and uninsured patients in the market. The point we stress...
Butler, the 10 minutes has expired.
Thank you, Chief Justice. We emphasize the point that conditions can be imposed along the Walmart approach merely to achieve the maximization of welfare. Justices, then, still on the level of approach and on the question of onus. My learned friend has referred you to the CAC judgment in Imerys, and in Imerys, Justice Rogers noted that it may not be strictly accurate to say that the Commission bears an onus in the sense of a burden of proof in relation to an SLC, but it concluded that if on all the evidence before the tribunal no SLC can be found, then the merger must be approved unless the SPI override operates, or if no SLC can be found and no SPI can be found, then the Commission bears the risk of non-persuasion. If there is no SLC and no SPI, the merger must be approved and can be approved with conditions. Only if there is a likely SLC do the merger parties then bear the risk of non-persuasion in relation to the justification aspects under 12A, 1A, Roman 1 and Roman 2. And if there is no likely SLC, but there are SPI grounds, then the merger parties bear the risk of their conditions not being sufficient. The reason why we emphasize this approach at the outset, Chief Justice and Justices, is that in the submissions in the heads of argument for the Commission, and from time to time in the oral submissions before you today, there was a mixing of the submission that the merger parties bear an onus to establish efficiencies. The merger parties do not bear an onus to establish efficiencies in the inquiry whether there is an SLC. Whether there is an SLC must be established on the evidence available. Only once there is an SLC do the merger parties attract the burden of non-persuasion and therefore would be obliged to set out facts justifying the merger. That then brings one, justices, to what may be the most important aspect of approach, the constitutional and contextual considerations. We say that these may be the most important because in due course our submissions to you will be that this court's jurisdiction is not triggered and implicated on the facts of this case. At the risk of repeating one of the submissions I have just made, whether there is a likely SLC is a matter simply of analyzing the structure and competition dynamics in the relevant market with and without the merger. Broader considerations are accommodated under the SPI evaluation, but of course they must meet the standard of substantiality. There is no mischief or concern if one observes that distinction. There's no risk that broader concerns, such as those raised by my learned friend relating to healthcare, will be overlooked if one observes the distinction expressly created under Section 12A of the Act. In this matter, you know, and my learned friend has referred to certain parts of the decision, the CAC expressly was at pains to recognize the constitutional and social values that infused the analysis. It noted that in regard to price effects, particularly for the topic that my learned friend has focused on, uninsured patients, that medical care is not a discretionary item, that healthcare is a fundamental right guaranteed by Section 27 of the Constitution. So there was no misdirection or something that the CAC overlooked in the SPI analysis. The CAC also was at pains repeatedly in its approach to recognize the purposes of the Competition Act itself, which create broader interests than just competition and are aimed at providing consumers with competitive prices and product choices and to advance the social welfare. So the correct description of the argument for the Commission in its approach to this court is that addressed by my learned friend in the second part of his oral submissions to you here. The Commission seeks to invoke this court's jurisdiction by asserting that under Section 12A(1)(a), the CAC erred in not having regard to the values under Section 27 of the Constitution. There is a further submission that the CAC did not give proper effect to the purposes of the Competition Act, and there is a third submission also referred to in oral submissions to you relating to certain observations of the Health Market Inquiry Report, the HMI report. Listening to our learned friend's submissions to you today, particularly in response to questions from the bench, it is not clear to us how, on the argument of the Commission, it asserts that Section 27 should play a role in the competition analysis under Section 12A(1)(a). We submit that on the approach of the CAC, it took appropriate account of the constitutional implications in the appropriate categories of the analysis. We submit that in relation to the HMI report, we've already referred to that earlier, the one aspect that the HMI report places particular emphasis on is this question of concentration in the private healthcare market and on creeping mergers. And on all the evidence before this court and before the courts below, this merger will not result in any concentration. We've given you the page references, justices, and it will not lead to any adverse aspect that the HMI has identified in the province to which it relates or in the town of Klerksdorp, city of Klerksdorp. No matter what disaggregated set of information one looks at, including, for example, the spread of hospitals in South Africa. You're aware from the evidence that to some extent or other, the hospital groupings have disadvantages in coverage in different areas, and in no respect on any of that evidence can there be a suggestion of implicating one of the concerns of the HMI report. Justices, that spread of information, in other words, the spread of hospitals, was dealt with two witnesses who testified, Dr. Conradi for the NHN. In particular, you may wish to have regard to volume 12, page 1107, as read with the documents that she testified to at volume 20, page 1953. In relation to creeping mergers, there is no evidence that Mediclinic has contributed to increased concentration by merger creep. We have given you the references to the evidence in our heads of argument at paragraph 52. And in this regard, we've also referred to the parts of the record in volume 16, 1604, paragraph 88 and 89, which show you that although there have been transactions affecting Mediclinic, they concerned matters where Mediclinic had moved from its original investment 16 years ago from joint control to sole control, none of which were of concern to the HMI. By comparison, justices, we know that the NHN, on the other hand, has grown substantially during the period of concern to the HMI. And the last reference in this regard, in case you're interested in seeing that growth by the NHI, is in volume 11, page 1002, as read with page 72 of the HMI report at the head of the page, where you'll see the substantial growth by the NHN. Justices,
you refer to section 27. Do the respondents accept that section 27 is relevant to whether or not this merger should be approved?
It is relevant, and perhaps Justice Tron, I could elaborate.
Yes, and while you elaborate, I'll also be interested in the interplay that the respondent advances between section 27 and section 12A.
That is in fact the topic I'll go into now, but if it is of assistance, in the analysis under 12A1A, that is essentially a competition analysis. We with respect, struggle to see how that which does not affect the competition analysis could nonetheless be said to affect the competition analysis merely because it invokes an aspect under section 27. Under the second part of the inquiry, the SPI analysis, all relevant factors can be taken into account. And of course, the fact that a particular interest enjoys particular protection under the Constitution is a factor to be taken into account, potentially, for example, in relation to what is substantial or not. But I'll come back to the elaboration of that reasoning in a moment, if I may. So, justices, on the evidence before you, on the primary facts, no price effects have been identified which meet the standard of substantiality, either in respect of an SLC or an SPI. And let me say immediately, I will deal with my learned friend's submissions on substantiality of price effects in relation to uninsured in some detail presently. The price effects relied on by the Commission therefore fall under, for its argument, would fall under the analysis under the public interest grounds. But that is not a matter of interpretation of section 12A1. It's a question of application, which of course we'll revisit in relation to your jurisdiction. Section 12A requires a holistic evaluation of the likely effects, dealing with distinct sets of concerns, first under 12A1A, as read with sub 2, and 12A1B, as read with sub 3 for public interest. Both sets together serve the key objectives of the Competition Act, as well as the broader concerns, including constitutional issues. On the facts of this matter, looking at the first inquiry, no broader concerns are relevant or of assistance in determining the question of the competition analysis. On the approach of the CAC and on the facts before you, that analysis can entirely be conducted with reference to the primary facts. That brings on then to what possible role Section 27 could play in the question of the first part of the analysis, the SLC analysis. And we submit it cannot play a role in that context. To be clear, the merger parties fully accept that in considering a merger's effects and whether they give rise to an SPI, then broader interests such as constitutional rights are pertinent and should be taken into account. But there is, we submit an error in the submissions for the Commission seeking to invoke that argument in the first part of the analysis. Justices, we suspect we may summarize the following, the submission that follows very briefly. In the Section 39.2 analysis, which enjoyed some debate between the court and our learned friend, in this court's judgment in McCarthy versus Vodacom, the two key principles were laid down: the obligation to interpret a provision, on our learned friend's argument, the interpretation of the words likely to substantially prevent or lessen competition. The interpretive provision is triggered when the provision itself implicates a right under the Constitution. Section 12A1 does not implicate or affect rights under the Constitution, does not affect Section 27, which is what our learned friends invoke. That process of interpretation is subject to two pertinent principles. The first, as this court reasoned in McCarthy, the interpretive approach can be adopted where a provision is capable of more than one meaning, and the alternative proposed meaning is one that the interpretation can reasonably bear. The words in question in this matter do not permit a broader interpretive approach that our learned friends apparently assert. And second, where the provision cannot reasonably bear that meaning, then the question is whether the words can be read in. But as we know, justices, when you seek to read words into a provision, which on the argument of the Commission is necessary, that can only be done once you have sought to implicate the validity of the particular provision that you are seeking to have read in under Section 172. No such attempt by the Commission has been made in this matter to implicate the validity of the provisions. And although our learned friend has sought to argue that there's a duty on the court in any event to take certain steps if it is concerned about a constitutional matter, that matter must of course properly be raised. In this matter, there is an application for leave to appeal in which such a matter has not been raised at all. Justices, to test the soundness and reliability of the submission that I've just made, if one takes the applicable words in this matter under Section 12A1 and read with 12A1A, our learned friends would effectively have that section read not is likely to substantially prevent or lessen competition, but rather there should be read into it additional words along the lines of, or in some other manner result in a substantial increase in prices or deterioration in quality, or other words to that effect. There is just no scope for that. And much more importantly, there is no need for any scope because broader concerns are governed by Section 12A in the second part of the analysis. Justices, so those are our submissions on the attempt to invoke this court's jurisdiction by arguing the interpretive point.
Sorry, Mr. Butler. If I could take you to Section 12(1)(a) Roman 1, the notion of efficiency. Is that not a value-laden concept? There's a notion of business efficiency, a traditional approach to that, but in the context of whether the Constitution applies, is there not a basis for a value-laden interpretation of efficiency?
Justice Pillay, certainly, although we would stress two brief submissions. The first is one doesn't get to the inquiry under 12A1A1 until a finding in relation to the former point is made, so that the offsetting points, as my learned friend calls them, would only arise after a finding of an SLC is made. And if I may say, with respect, the proposition that the court raises now merely reinforces the point that the statute is wide enough to take into account broader issues. The second limited submission at this stage, Justice Pillay, is simply, it is difficult to understand how on the facts of this matter, that jurisdiction would be triggered, for example, on the argument that my learned friend raises, because if at the end of the day, the court is of the view that there is no substantial lessening of competition and no substantial public interest, then no further inquiry in this matter would be necessary. If I may just have a moment. Yes, my attention is drawn, Justice Pillay, also to the words that follow, that the effects of any pro-competitive elements should also be taken into account. Yes. It's possible, of course, Justice Pillay, to read the words that you have referred to, technological efficiency or other pro-competitive gain, implying it might be that this is still a competitive-based analysis rather than a merging of that analysis with that under sub-Roman 2. In other words, our submission remains that the broader inquiry can be made, that it is appropriately made in its appropriate home. For the purposes of the submissions to you today, just to be clear about the appropriate housing of this debate, we've come to this debate on Section 12A1 because the Commission seeks to invoke this court's jurisdiction, and it has sought to invoke its jurisdiction in the primary interpretive argument. And we submit there is no scope for that triggering of this court's jurisdiction. It does so because it accepts, and this has been reinforced in my learned friend's argument, that the CAC appropriately recognized the constitutional and broader social implications when conducting the second part of the analysis.
Mr. Butler, I meant to raise this question with Mr. Mbikiwa, but I think I should raise it with you because you have submitted on a number of occasions that the jurisdiction of this court is not engaged. Doesn't the fact that the CAC has applied constitutional principles in deciding the matter raise a constitutional issue? In other words, you said in an answer to the question by Justice Theron that Section 27(1) is relevant in determining whether this measure should be allowed. Now, doesn't that really say the matter involves constitutional issues? And therefore, the jurisdiction of this court is engaged. It may, on your argument, it may not be engaged at an interpretative level. But for one to say the CAC was correct in approving the measure, one will have to go through the reasoning of the CAC, including the application of the provisions of the Constitution. Can we still say then that the matter doesn't raise constitutional issues?
Thank you, Justice Chafter. So my learned friend, Mr. Bakir, will deal with this fully, but if I could answer you directly now. The question whether the fact that there is a constitutional value relevant to an inquiry does not, on this court's approach to its jurisdiction, trigger its jurisdiction. If I could explain what I mean by that. Outside of the context of the competition analysis that we now look at, every matter involving a criminal case involves a constitutional right, the right to liberty, which is not meant in this court's approach to its jurisdiction that its jurisdiction is triggered merely because there is a concern about a constitutional right. And there is a particular analysis that has to be followed before one concludes that its jurisdiction is triggered. And to sum up the point, Justice Chafter, if ultimately the analysis is a factual one, then this court's jurisdiction is not triggered, or if it's a matter of applying a tried principle, it's not triggered.
Now, there's a difference between the jurisdiction based on whether or not there is a constitutional issue raised, and a jurisdiction based on whether or not an arguable point of law of public importance is raised. So those are different. So the issue of whether the law is settled on that particular point doesn't apply to whether or not a constitutional issue is raised in the matter. The question of determining whether a constitutional issue arises is to look into whether it was necessary for the court below to apply constitutional principles in order to arrive at its decision, because it is the correctness of that decision that is being tested in this court. But I'll hear Mr. Mbihiwa on it, as you say.
If I may be of assistance, Justice Chafter, he will deal with that, but if I could perhaps try and create a framework for the assessment of the analysis that you propose, and look at the approach that the Commission has adopted in trying to ground the very point that you raise, which is the public interest and the uninsured in particular. So there, as we understand the Commission's argument, they raise what they consider to be the strongest argument to advance the proposition that you put to me. So if I may then deal with the question of the uninsured and the public interest, because there it is where theoretically on our learned friend's approach, one could see a role that Section 27 might play. Justices, as always in this matter, in the dense factual background to this matter, one has to begin with the correct facts. And with all of the correct facts, in other words, try and be as balanced as one can in looking at all of the facts. If I may use a shorthand reference, since the court now knows it well, that analysis which we invite you to take the approach of the Commission, which is to start with paragraph 25 of the CAC's judgment, a paragraph the Commission likes. And if we just look at the primary factual material that is before you. Now, I will omit reference to percentages for the reasons outlined at the beginning of the hearing by the Chief Justice. But at paragraph 25, one sees that there is a range of difference in the third line, comparing the tariffs for uninsured at Mediclinic compared with the target hospitals. And that converts into the effective difference in the third line from the foot of the page, because the component to which that element, tariff, applies only makes up 68% of the hospital bill. You see that 3 lines from the foot of paragraph 24. Just to be clear, only looking at one component of price, which is tariff, and applying weighting to that component, one gets a difference indicated by the CAC in the third last line from the foot of the page. All of this taking no account of other efficiencies. The question of other efficiencies is the subject of substantial evidence. The first that the court already knows about is procurement. Justices, you know from the facts that Mediclinic bills out its procured items at cost. That is, the references are given to you in our heads of argument at paragraph 112, footnote 139. You also know that one of the elements going to cost is called surgicals. In the language of the ordinary person, that is gloves, masks, everything that's consumed in the hospital, including prostheses and so on. And the other element is called ethicals, which are medicines. Medicines are governed in South Africa by legislation where there's one price, but surgicals are the subject of procurement advantages. Justices, you've been given the benefit of what Mediclinic achieves by its procurement because it's given in paragraph 24 of the CAC judgment. The correct figure, I'm referring to the incorrect page. The procurement advantage is given at it's a paragraph 154 of the judgment. And we know that that figure, which I won't repeat now, is a substantial reduction in price, just based on procurement of surgicals. My learned friend has sought to persuade you that you should really disregard that. You should disregard it because there's been no quantification. With respect, there has been quantification by both sets of actuaries, and this is an undisputed figure. And there's no difference between insured and uninsured because the same surgicals are procured. There's no suggestion that Mediclinic goes and buys us syringes for the insured market and other syringes for the uninsured market. It's the same basket of procurement to which the same procurement advantage, substantial procurement advantage applies. So just in relation to procurement, the figures 3 lines from the foot of paragraph 25 reduced by that figure. And then thirdly, justices, as you know from the actuarial evidence, and this is provided in the report in the judgment of the CAC, the question is, taking all things into account, how do the comparable Mediclinic hospitals compare with the targets and those appear at page 71 of the CAC judgment, page 3556 of the record. And there we refer you to the first line, where on the acceptable comparison.
I'm sorry, Mr. Butler, which paragraph number?
So page 71, paragraph one, the table just after paragraph 196 of the CAC judgment.
Thank you.
It will make things more efficient later in my argument if I just spend a moment on this table just to explain what it shows one. Justices, in this table, which is a collation of all of the information of the actuaries, you'll see that on the shaded part of the table on the right, there are differences calculated by Alexander Forbes, the actuaries or the firm for the commission, and the left-hand side by Insight, where Mr. Childs was the actuary. And what one then can look at is comparisons. The first row, where on the left one sees MC7 and targets, we have the data for each year's 2014, 2015, and 2016, and then one has the average. And I won't repeat it for confidentiality purposes, compared to the calculation of the firm for the commissions, and there is a slight difference between those two figures. In my submissions that follow, it will not be necessary to decide whether one figure or the other is correct, because ultimately you will end up in the same position in our submissions, and that is that there is a substantial efficiency overall if one compares like with like. So that is a further efficiency introduced into the analysis by the actuaries. It is not realistic, we submit, for the commission to argue, well, you can just ignore that in uninsured. There's no suggestion that hospitals treat uninsured less efficiently than insured. This is the data of all of their admissions. We know that in 1 year, there are about 13 to 15,000 admissions. This is big data, giving you these calculations. My learned friend makes light of the distinction in the qualifications of the actuaries. We submit that you don't need to decide whether one figure or the other is correct. There's just this range of those two figures. But in case it's of assistance to you to know, in paragraph 162 of the CAC judgment, it provided substantial reasons for respecting the views of the actuary for the merger parties. And one reason, for example, is that the Insight actuaries consult to all the major players in the healthcare industry on both sides of the debate, to the hospitals and to the medical schemes. So they are trusted and relied on. Mr. Saeed, and I mean no disrespect to him, was an actuarial student with no claimed experience similar to that of Insight. But I stress, to make a reliable finding on neutral evidence, the court can accept those efficiency ranges. Justices, to come back to the uninsured. Sorry.
Let me wait until you've addressed the uninsured. Yeah, thank you.
So justices, where does this bring one in terms of reliable information? At the foot of page of paragraph 25 of the CAC judgment, that range given in the third last line can be reduced reliably both by the procurement and by the efficiency differences, which still leaves one with a slight increase in price, a range perhaps, and so one doesn't know exactly where that range is, but still an increase in price. And again, to try and attempt to place the facts as neutrally as possible before you, also bearing in mind that
with the first figure you gave us on efficiencies, the difference would still be in double figures. I'm not sure that I follow the figures in that columned document. So I can't quite tell if you add the first figure you gave us to the figures in the column document, whether or not the difference would now drop below double figures. Are you able to enlighten us on that?
I hope so, Justice Madlanga.
Double digit, I mean, double digit.
I hope I can help. What you will end up, just to answer your question directly and then perhaps give the reason for the answer, you will end up with a range where one part of the range is in single figures and the second part of the range is just in double figures. And for present purposes, we ask you to accept that there is therefore, as a result, a difference in price of increase, again, to be completely neutral and reliable about this. And we want to be sure that we try and convey facts as reliably, also bearing in mind that there is a difference in discounts that would operate in favor of our learned friend's argument. So that's where the position lands. The point that we want to make is it's not the alarming difference where our learned friend says to you, just take into account the tariff difference. You see this enormous difference in this matter, and therefore the onus shifts to the merger parties. That's with respect to an unreliable submission, because the question at the end of the day is what happens to the price. And we have reliable evidence of the benefits of procurement and efficiency. The second...
May I ask you, sorry, these actuarial calculations, what impact, if any, did the procurement exemption that NHN was able to secure have on these calculations? The commission says it rendered the entire calculations irrelevant. What is your take on that?
We'll come to that in some detail, Justice Majid, but the answer will be nothing, or certainly nothing that this court can have any regard to. I'm not suggesting, to be very clear, that in forecasting, the CAC could not appropriately apply some forecasting benefit, and it did so. And I'll show that to you in a moment. So justices, when considering the question of the price increase and the important issue of substantiality, we ask you to accept that in relation to the resulting price, it is the figure given 3 lines from the foot of paragraph 24, reduced by the procurement benefit figure and the efficiency figure. It is so, as my learned friend said, that the actuaries could not do a comparable CPE calculation because the data is so limited. And with respect, it's a little unfair of my learned friend to place that at our door for 2 reasons. It's for the commission to bear the risk of non-persuasion on an SLC or an SPI. Secondly, all available reliable evidence has been placed before the tribunal and it is comparable. And thirdly, if the real reason why a reliable calculation can't be done is because there are so few patients to whom this applies, then that is a consideration that has to be taken into account in relation to substantiality, which I'll come to presently. Justices, I will turn now to the numbers issue. We know that about 2 to 4% of admissions in the target hospitals fall into the category of uninsured or private patients. To put it slightly differently, for the reasons that will follow, about 96 to 98% of all affected people fall into the scheme price effects debate and not into this debate. I stress we do not suggest that this court should not take into account the concerns of a few hundred people who are admitted, or rather a few hundred admissions, bearing in mind that some people may be admitted more than once. That, of course, is a matter that one has to have regard to, and the CAC did have regard to. But we are dealing with a very small part of those affected by the merger, and in the discussion around substantiality, one must, of course, take the whole merger into account, giving appropriate weight to those who are protected by the Constitution. In relation to the people who qualify, who seek private, who are private patients, not medical scheme patients, just one small submission. These are not the typically indigent people who are affected by the price of bread as a group. I'm not suggesting one can say as a rule. These are people who choose to seek private healthcare at private healthcare rates and who have not chosen to insure for reasons which of course may be varied. But we are dealing with people who have been admitted and who could afford to pay for the private healthcare, and they just fall into that category. I make no more of that other than to raise the fact of exactly that particular categorization of these people.
I'm sorry, Mr. Butler. Do we have evidence on that point, on record, that these are the people who choose to go for private healthcare instead of public healthcare?
Justice Jafta, we submit that the fact of admission into a private hospital speaks for itself. In other words, you know the one fact is they're uninsured, and you know the fact is that they've chosen to go to private healthcare. I stress, I'm not saying that one can say this about every individual. It may be that somebody's had an accident nearby and it's an emergency and so on. But you know that as a group, they are people who can afford and have paid for private healthcare.
In a country like ours, where we know that the type of service in public facilities is so poor, below standard, can we characterize it as a matter of choice when people go to private facilities? Of course, to get service from the private facility, they'll have to pay for it. Now, I'm worried by the statement that this is a matter of choice.
So Justice Jafta, I'm not, forgive me if I've overstated one particular aspect of the submission. The submission that I was trying to make is the economic profile of the people who are compared to, for example, my bread example. When it comes to the substantiality analysis, in other words, if you are dealing with the example of an increase in the price of bread, you would bear in mind that those who are affected include the poorest of the poor. In the case of, as a generalization, those seeking healthcare, and there are public facilities in the region, then you will bear in mind that the people being admitted as uninsured are those who are able to afford private healthcare.
And in determining the issue of substantiality, do we have to consider their right of access to healthcare?
Yes.
The small number of them, aside, do we have to consider that?
Yes. And to put a perhaps what is a helpful pin in that point, Justice Jafta, one could consider it in exactly the same way that the CAC emphasized it. The CAC focused on these people and their interests and the particular right in issue.
Then doesn't it mean that even at the level of interpretation, we have to invoke Section 39, sub 2 of the Constitution, in the sense that we have to say, or we have to prefer a meaning of substantiality which is going to advance rather than disadvantage access to healthcare by those who are going to be affected by the measure.
Justice Jafta, I must unfortunately answer your question with two submissions, and I know you prefer one, but if I may just clarify it by making two submissions. The submission is that the mere fact that a particular assessment of what is reasonable, what is substantial, might be relevant to a constitutional right does not invoke this court's jurisdiction. And the example, perhaps the easiest one, is the one I made earlier. The sentence handed down on a prisoner in deciding whether the sentence is reasonable or not would, on the argument of the prisoner, require taking into account the prisoner's constitutional rights. But on the jurisprudence of this court, that argument on its own is not a matter falling within this court's jurisdiction.
I'm not quite sure whether I follow that analogy. One, if the trial court in a criminal matter has, one, conducted the trial fairly, the prisoner doesn't complain that my trial was unfairly conducted. And two, a sentence was imposed and the prisoner doesn't complain that in imposing the sentence, the trial court misapplied the law. The prisoner merely says, in imposing this sentence, the trial court did not take into account these personal factors or attach adequate value to my personal factors. That would not engage the jurisdiction of this court. But if the prisoner were to show that in the imposition of the sentence, there was a breach of a legal principle by the trial court, that would engage the jurisdiction of this court, because the effect of it is to deprive the prisoner the liberty. So I think your characterization is not quite following what this court said in Busak, for example. In Busak, this court said all what Mr. Busak is complaining about is the evaluation of the facts and the determination of whether those facts were adequate to support or sustain a conviction. He is not complaining of any misapplication of the law. So I don't understand the example that you were giving me in that context. I agree with you if all what is involved doesn't touch on any legal principle, it's a mere question of evaluating the facts. Yes, it doesn't engage our jurisdiction. But if what is being done is to test whether a legal standard has been correctly applied, and that legal standard implicates, or the decision that flows from the application of that legal standard implicates a right guaranteed by the Constitution, that engages our jurisdiction.
Justice Jaffe, if I could leave the analysis of the broader principle to Mr. Mpikiwe, I do appreciate you'd like clarity on that.
Yes.
But if I could illustrate, the reason for saying that is just to illustrate in relation to the uninsured debate, which is where this debate is, as we understand it, finds purchase. What the Commission submits, to the correct categorization of the submission to you by the Commission, is that the CAC, in deciding what was substantial public interest, erred. That's the categorization of the submission to you. And that submission we submit is a finding of fact, or at worst, the application of a principle to the facts, which does not engage your jurisdiction.
Well, I understood him to take it further than that, to say the result of that, the result of leaving out the impact of that definition of substantiality on the affected group of people is that their right of access to health is affected. That's how I understood the argument, or perhaps it wasn't in those terms.
So Justice Jafta, if I could just try and summarize the submission that my learned friend made to you as we have it. You'll recall that in advancing the argument for the commission, our learned friends particularly like certain observations of the CAC as to what the effect on those uninsured might be. And you'll recall that our learned friend, on the one hand, embraced, and on the other hand, had to concede a passage in the judgment of the CAC acknowledging that there might be price increases for uninsured in the particular market. In other words, the factual foundation is there, but why it has to be a concession is that the CAC correctly analyzed the factual implication. That then raises the question of categorization that you raise, which is, on those facts, is it substantial? And our submission is that that is primarily a factual question. Our learned friend's argument really comes down to saying, we submit, that because in the background lurks a constitutional right, then any assessment of the facts necessarily invokes a constitutional matter and this court's jurisdiction. We submit that's a wrong approach. On this matter, what are correct facts identified by the CAC and the CAC's assessment of whether they are substantial is the issue. Because if that is where the debate turns, and on our learned friend's argument that is where it turns, that is primarily a factual assessment.
All right, I may have understood his submission differently, but I hear what you're saying. Thank you.
Thank you. Thank you, Justice. So, Justices, I was dealing with the primarily with the facts relating to the uninsured. I've dealt with the numbers that we've referred to. I have dealt with the fact that 96 to 98% of the market would, on the assessment of the CAC, be advantaged, and that even this last percent would be advantaged by the application of the condition. The question then is the question of substantiality, and I'm just trying to get back to my place where I was making the submissions. And our submission then, as engaged in the debate with Justice Jafta, is that these are not substantial public interest grounds when all of the facts are taken together. When all of the facts are taken together, including the benefits to the insured market. Justices, there's an important issue raised in the debate by my learned friend with you, and that is on the question of a discretion whether to impose conditions or not. If this court were, as the court knows, the CAC did impose conditions, which the CAC...
Before you get to that, Mr. Butler, you may have touched on it, but please remind me. Before we get to substantiality on the lessening of competition, do you accept or do you not that there is a lessening of competition?
There is, in the indirect sense, acknowledged by the CAC that if word gets out in Klerksdorp, which it might, that Mediclinic is now in town and it has a different tariff file than the target hospitals, it might be that Life Ancron could respond by a way that's not desirable in the market. There is that potential impact. But I must immediately stress two things. The one is this was not overlooked by the CAC, but given particular attention. And the second fact is that the question still remains whether this is a substantial lessening of competition, taking all the facts into account fairly. Then just to go back to the question of the discretion and the remedy, a question that may concern this court is if the court has a concern about the CAC's assessment of an SPI, and assuming for the moment that that is the view of the court, what trickle-down impact does that have on the assessment of the competition tribunal's reasoning on the remedy? And it's necessary just to spend a moment on that. The question ultimately will then translate itself into, could the CAC, applying the question of what the Commission applies as deference, bearing in mind that this is a discretion, could it interfere with the reasoning of the tribunal in relation to the conditions for uninsured? And Justices, it is in this regard necessary briefly to refer you to the reasoning of the CT in regard to the remedy offered for uninsured. Hopefully, efficiently, I could just give you a few basic facts. The merger parties offered a remedy that my learned friend has referred to, their first remedy, in relation to uninsured, and boiled to its essence, it amounted to a 3-year remedy where the uninsured who came to the target hospitals after the merger could choose to use either the target hospitals tariffs and discount or the Mediclinic tariffs and discount at their choice. The Competition Tribunal considered that too complicated. How would they make that assessment? And so the remedy that was then offered is the one you'll see in Annexure X to the CAC judgment, which is to maintain the tariffs of the target hospitals for 5 years, applying the same tariffs and the same discount policy at the target hospitals as currently applied. That was considered to be, by the CAC, to be appropriate. If one looks at the reasoning of the tribunal on the question of remedy, and Justices, if you'll just note the pages, they are in volume 34, 3433 to 3434. And in that context, the tribunal made 3 observations. The first observation at paragraph 420 was that there's a problem with the remedy because how would the insured be able to choose between the 2 discounts being offered? That can only make sense if what the tribunal at that stage had in mind was the first remedy. That doesn't make sense with regard to the second remedy. And it appears, therefore, that the tribunal may inadvertently have had regard to the wrong remedy. At 421, the second criticism was that no actuarial supervision and reporting was offered. That is offered in the second remedy. One sees that in clause 4 of the remedy attached. So we submit that on any basis, the CT had inadvertently, unfortunately, apparently had before it the incorrect remedy. Regarding duration, the CT said that the duration was limited. Before the CAC, and again in our heads to this court, the merger parties, Mediclinic, has offered an indefinite remedy if that is of concern. and also to apply the maximum discount percentage if that is of concern, given the issue raised by my learned friend. So, Justices, on the question of the uninsured and the SPI, the position lands with the submission that the CAC correctly identified the issues, correctly placed this concern under the SPI analysis, which one would have thought the Commission would like, because it then creates the broader inquiry, correctly identified the constitutional and statutory concerns, and correctly identified the relevant facts in a manner which reveals no misdirection. Justices, I intend to move on to the question of automatic price effects and whether an automatic price effects constitutes an SLC, which is the last part of the argument raised by the Commission for the engagement of this court's jurisdiction.
Mr. Butler, before you proceed, perhaps can you give us the reference to where that remedy was, or the indefinite nature of the remedy was before the tribunal?
It wasn't before the tribunal, Justice Trotter. It was before the CAC, I said a moment ago.
Okay, so that offer was not made before in the tribunal?
No, but to make it clear, it remains the position of the merger parties that any duration is acceptable, any discount is acceptable. The CAC left this question on the basis that even on the 5-year remedy, plus the target firm's discount, that gave substantial benefits to uninsured patients. Ultimately, as you have inferred from our argument, a question of fact, which we submit is a.
Mr. Manechi said that offer should have been made before the tribunal.
It may have been made before the tribunal. At this stage, Justices, we tell you for what weight it may carry in your assessment, that it was made before the CAC. There has been some shifting of the ground in the attempt to put further evidence before you, and we leave it in your hands as a matter of justice. But the correct legal categorization of this submission is the one already made, which is that the CAC committed no impeachable misdirection in this regard. Justices, then on the question of automatic price effects, this has already been the subject of some submission in the interpretation debate earlier. At paragraph 137, I'll just read it to you briefly. This is a paragraph my learned friend liked of the CAC judgment. The CAC reasoned that taking into account the possible effect on the uninsured, it is possible that prices might go up. This reverts to the question asked of me earlier by the court, and I've dealt with the question of substantiality in this context. In the reasoning of the CAC that the argument for our learned friend focuses on, the submission is made that the CAC misdirected itself in considering as a relevant factor that any change in price would not occur as a result of a significant competition aspect. And his argument to you is that's incorrect as a matter of law. We have already made submissions as to whether that engages your jurisdiction as a matter of constitutional law, but at this stage, we simply refer you to what we have submitted above, which is the entirely logical distinction that Section 12A creates between the first and the second stages of the inquiry. The emphasis placed in Section 12A1A is on competition aspects. And so any change which is merely a reorganizational change or a change coming as a result not of a less substantial lessening of competition does not trigger Section 12A1A. Justices, I must now turn, in the efficiency of time, to the question that my learned friends spent some time on, which is the question of scheme price effects. I'm mindful of the limitations, and if I could then at the outset...
But why not? Why not on the pricing issue?
Sorry,
you refer us to your submissions on that point, but I'm saying I want to understand your argument. All that I saw in your submission was a reference to the decision in Lakeview, but that has no general presidential value, because in so many words, the decision there says, we make this decision purely on, or rather based on the facts of this matter. So no presidential value. So aside of Lakeview, what's your other basis for your argument in this regard?
Justice, it's that advanced in our heads relating to the structure and language of section 12A1A, which we do deal with. This is dealt with in our heads at page 17 through to 21. And if I could just give it to you, I hope pithily, the focus of the Competition Act, and particularly the analysis under 12A1A, is a concern about a change in competition, and more importantly, a substantial change in competition. So bearing in mind that what on the current approach might be a step change in price, and I'll explain to you in a moment that there is no concern about a step change in price, certainly in relation to scheme price effects. I've already dealt with uninsured. But as to the question of substantiality and the question of substantial competition change, the reasoning of the CAC we respect is unimpeachable. What the focus of section 12A1A is whether there is a lessening of competition. If a price change occurs for another reason, it may have broader implications, we don't deny that, but it is not primarily a competition concern. So justices, on the scheme price effects, which is again where we submit one lands on the facts, if I could just give you the passages in case I miss them later, in our heads, pages 21 to 36 is what we were discussing now, and in the CAC judgment, paragraphs 159 to 207. Forgive me if I run briefly through the primary facts, but I've already covered them in relation to uninsured, and I will certainly spend more time if the court prefers me to. There are the components of the overall price. Those are tariff, surgicals, ethicals, and efficient conduct. Those all go towards making up the price. The reason for repeating that submission, justices, is that even in this context, our learned friends erred occasionally in treating tariff as though it is the price. Tariff is a component, but it must be seen with all of the other elements that make up price. I've shown you earlier, justices, the pages in the judgment of the CAC where that analysis is done in detail, taking all of the available data and information together. So justices, where that lands is that because of the difference in tariff, one doesn't have that equivalent change in contribution to price because only a portion of the hospital bill is made up of that to which the tariff applies. There is a major procurement advantage, as you know from the facts, that Mediclinic enjoys, applying to only 1% of the total bill, but the procurement advantage completely offsets the tariff disadvantage. And then thirdly, because of efficiencies, and to be clear about efficiencies, these are efficiencies in utilization, in other words, how long people spend in the theater, how long they stay in the ward, whether more expensive or less expensive surgicals or ethicals are chosen, whether the hospitals administer original patented drugs or generics and so on, there is a major resulting efficiency on any basis. Apart from the detailed analysis of the CAC, the merger parties also put up the foundational evidence before you, before the tribunal, excuse me. And importantly, in that evidence, there were the reasons why the NHN and the target hospitals cannot match the efficiencies in procurement and utilization. Very briefly, Justices, you have it in the heads. On procurement, it's a question of size and not just of size. It's a question of ranking and focusing procurement through a ranking process. In other words, if you leave it to 62 hospitals to pick and choose whatever surgicals they want, you can't focus your procurement. If you as a hospital, a group impose a ranking system, you can. The NHN cannot impose a ranking system on its hospitals because they are disparate and non-aligned. When it comes to efficiencies, all of the evidence, including from Mediclinic and the target hospitals, was to the effect that what you need to be able to do is to have detailed peer review data that allows you to engage with the specialists to alter their behavior. There is no access to such data on the part of the NHN, and none was ever referred to. So, Justices, we submit that whether one accepts the Alexander Forbes figure or the Insight figure of resulting efficiency, the Mediclinic groups are substantially more efficient. Our learned friends now argue to you, well, they may have lost that battle, but what they'd like you to do to try and render that battle irrelevant is to assume that historical data is not forward-looking and you can more or less ignore that. With respect, this is a surprising submission, although it is one that was been made before. And just very briefly, Justices, the Competition Commission presented its case to the tribunal on the basis that the comparable efficiency data, the relevant comparable efficiency data, is relevant and is a helpful guide in working out whether efficiencies in the comparable hospitals can be matched with one another. If you could just note, please, in Appeal Volume 7, page 622, paragraph 106, and 626, paragraph 119. This was the case that the Commission presented. When, however, the actuarial evidence came out, in other words, when one compared like with like, one took a representative sample of hospitals to compare with one another, the position of the Commission changed. It did two things. It instructed its actuary to select only one hospital from Mediclinic as a comparator, despite the actuaries disagreeing with that approach. They preferred more comparable data rather than less comparable data. And secondly, there was this criticism that my learned friend referred to a moment ago that said Mr. Childs chose the most efficient hospitals. That's with respect to my learned friend not correct. That's not what the evidence was. Mr. Childs used an approach which was to choose hospitals that were of similar size and certain distances, broadly speaking, to the target hospitals. And he found that once he had done so, there was a particular profile to those hospitals. To come back to Discovery, which my learned friend criticized for not being called, Discovery's reports essentially said the same thing, that if you look at size and efficiency, you see a particular profile. So with respect, Mr. Childs did not reverse engineer any result. He chose hospitals that Alexander Forbes did not criticize. So the data with respect is reliable, and to make the same submission that we've made before, it is a factual matter, an entirely factual matter. Justices, that then brings one to the procurement exemption. This is dealt with in the CAC judgment at 143 to 146, and 152 to 153. After the evidence had been led, and shortly before argument, the Commission granted the exemption. As my learned friend has briefly summarized it to you, the exemption was to permit the NHN to procure centrally, and that was subject to a qualification that the hospitals falling under the NHN had to comply with certain requirements. One of them that's relevant for present purposes is that they had to be either small or a firm controlled by historically disadvantaged persons. It's common cause that the target hospitals do not qualify. Unsurprisingly, both the tribunal and the CAC therefore considered that the analysis should be limited to 2 years. So there can be no criticism around that issue, and our learned friend, unsurprisingly, does not criticize it in that regard. I've already made the submission to you as to why Mediclinic is so good at this, and that is it's not just a question of size, as my learned friend submits, it's a question of ranking in order to focus procurement. And of course, as one knows, in one paying creditors, price terms, discounts, and so on all have to be negotiated. The NHN has no similar ability. As the CAC noted, it's a collection of more or less independent hospitals or groups in some cases, and no ability to impose its ranking on its members. There's no evidence that the NHN has any national or international expertise to choose an appropriate ranking, bearing in mind that when you're dealing with specialists, you need to be able to persuade them that your ranking is a good ranking, given the clinical choices that they have to make. Third, the CAC's reasoning is neutral and balanced on this issue. It takes a realistic view of it. The CAC reasoned that it was unlikely that the NHN would kick off this project immediately. There may be a substantial lag time of up to a year, and that realistically, there would be some benefit, but the benefit may only be partial. On the CAC's approach, that could be half of Mediclinic's efficiency, and bearing in mind that if that's half of the figure that I showed you earlier, were applied to the figures on the table at page 71 of the actuaries, then Mediclinic is still more efficient than the target hospitals. So in that middle of the road, neutral approach to procurement, there is still a substantial efficiency that Mediclinic would bring to bear, even on the procurement favorable assumption. The CAC did not blinker its approach. It assumed, for example, that the target hospitals might even be greater and might push those figures into the positive, in other words, push them above naught. But in that scenario, it reasoned that that would then be a transitory benefit, because after 2 years, the target hospitals would no longer comply, and then the prices would, on the non-merger scenario, be much more expensive than on the merger scenario. Those are the facts, Justices, and our submission remains. There's no reason to interfere with them, and certainly not in this court's jurisdiction. That brings one then briefly to the further affidavit, and we've explained our position in our heads, and if I could summarize it briefly as follows. The further information is to tell this court that the grace period has been extended until October 2021. That's 7 months from now. The primary reasoning of the CAC remains in point. It doesn't dislodge the CAC's reasoning in any way. All it does is it gives an extra 7 months. So you still end up underwater, as it were, on the middle ground scenario. And even if you assumed in favor of the Commission that there might be a greater benefit, it is transitory, really just for a slightly longer period. So that's the primary point. The second point, as we've made in our heads of argument, is that this information was available and should have been given to a CAC. The Commission explains to you that it chose not to do so because it was concerned that there might be opposition. With respect, that's not a basis for not putting up the evidence. The question is not whether what the opposition would think, the question is what the court would think. there was an election not to place this evidence before the CAC. And more importantly, Justices, if one steps away from particular rules around accepting evidence, the question before this court at the end of the day, in the interest of justice, is this. The Commission has effectively given you what we would call is something of a half fact. We mean no disrespect, but the reason why we say that is that telling you that the grace period has been extended merely raises the question, well, what does that mean? What's been done in the meantime? And the Commission makes no attempt to tell you that important fact. You know from the evidence that the NHN has cooperated with the Commission, and it could simply have been a phone call to ask the NHN for what has happened in the meantime to tell this court candidly what this additional fact means. We ask you, if you are going to receive the further fact, also to accept our affidavit, which tells you the answer to that question. And the position then that remains is that the analysis of the CAC was the appropriate analysis, and there was no reason to interfere with it, ultimately also because it was a question of fact. Justices, then very briefly on two remaining issues on scheme price effects. There is a matter that repeated itself in the evidence numerous times relating to alternative reimbursement models. Very briefly, Justices, an ARM is what medical schemes like, and they like it because it stops paying hospitals on a fee-for-service basis. The HMI had some words to say about this. Among the approaches of the HMI is that ARMs are the future of healthcare. One has to stop the process of adversely incentivizing healthcare providers by just paying on a fee-for-service. This is a consideration that features throughout the reasoning of the HMI. On the evidence before you, there is substantial evidence that Mediclinic is advanced in relation to matters involving ARMs relative to the NHN. Justices, that appears from the discovery evidence. It appears from the cross-examination of Mr. Marion. And if I could just give you, without having to ask you to turn to it, in the HMI report, paragraphs 133, 134, 140, 154, 155, 195. On the evidence on the record before this court, the comments by the major medical scheme in South Africa, Discovery, Appeal Volume 3, 279, 280, 281, and 282. In the examination of Mr. Marion, the record references are 3245. Insofar as an unquantifiable element of the merger, unquantifiable because there was no data to compare ARMs with ARMs, one knows that there is that additional advantage that the merger offers. And then lastly, regarding conditions, I've already indicated to the court what those advantages are. Justices, that brings one to the competition analysis relating to uninsured patients that my learned friend touched on briefly. And his criticism of the CAC is that it performed no particular analysis of competition. I've already indicated, Justices, that in relation to paragraph 137, his submission is not fair because the CAC specifically had regard to what might happen if the uninsured tariffs increase. But the analysis of the CAC is with respect comprehensive. On geographic market, paragraph 69, on public interest at 126, on the analysis of prices and the impact, paragraph 25, which my learned friend referred you to, 136 and 137, and on remedy, 217. That, with respect, is a comprehensive analysis of the competition aspects relating to the uninsured. Justices, that brings one to an area which I suspect I've run out of time to cover, which are grounds of appeal that weren't really advanced in the heads, and my learned friend has not addressed. They are matters such as the geographic market. If I could just give you the page references in case they become relevant to you later. The CAC judgment at 44 to 97 we submit is comprehensive and reveals substantial misdirections by the tribunal. On scheme network effects, paragraphs 100 to 123 of the CAC judgment, which again respectfully reveals substantial directions by the tribunal. And on patient experience, the CAC at 68, 210, and 258 to 259 reveals substantial misdirections, excuse me. Justices, my colleague, Mr. Bikiwe, will address you on the questions of this court's jurisdiction, if I may then ask him to address you on that.
Yes, Mr. Bikiwe.
Thank you, Chief Justice. Justices, it falls to me to address you on the question of this court's jurisdiction, and I do so mindful of the concerns that have been raised by Justice Jafta. If I may, I'd like to return to those two concerns as I have it at the end of my brief address. And I'd like to begin with what we consider are three fundamental principles that apply to this court's determination of whether it has jurisdiction to entertain an appeal. The first of those principles is perhaps the most elementary one, and it is that the question of jurisdiction is determined on the pleadings. That is what this court held in Jiba, relying on its earlier decision in Haba. And in fact, the court in Jiba went back to the General Counsel of the Bar's High Court pleadings to determine whether its case had ever been one that either implicated the Constitution or that was anything other than the application of an established legal test to the facts. Justices, I won't take you to the Commission's mergers and acquisitions final report, which is effectively the founding document in this matter. But you will see from that document that this case has always been about the application of Section 12A, not any development of the way in which that test ought to be applied, and indeed not even about interpreting it, but simply how Section 12A ought to be applied. And that, with respect, leads me to the second jurisdictional principle, which is this. This court has held that it does not raise a constitutional issue or an arguable question of law to allege that a lower court is either wrong on the facts or that it merely misapplied an established legal test. And Justice Jafta, this perhaps deals with the second of your concerns and your reference to the case of Busak. If I may refer you to Boyson's case and the judgment in particular of Justice Mhlantla, where the majority of this court held that in order to raise a constitutional issue, an applicant must allege that the test itself does not comport with the Constitution in some way. The mere misapplication of an established legal test will not implicate this court's constitutional jurisdiction. And you will recall that Boyson was a case that didn't involve this court's jurisdiction to hear arguable questions of law of general public importance. It was a case focused squarely and only on this court's constitutional jurisdiction. And if I may refer you to paragraphs 48 to 58 of that judgment, and that's the judgment of Justice Mhlantla. Justice Mhlantla deals with jurisdiction at paragraph 48 as follows. She says that the first question is whether this appeal raises a constitutional issue. The applicant in her founding affidavit argues that the constitutional matter raised for consideration in this application relates to, quote, the application of all relevant considerations, and in particular the normative factors considered in a constitutional setting of the Bill of Rights in respect of vicarious liability on the part of servants of the state. Importantly, Justice Mhlontle notes, the applicant does not argue that the test for the imposition of vicarious liability is at odds with our constitutional order, or that it requires development. And this is the important part of paragraph 50. In the context of the applicant's submission, the constitutional issue in the present case is the application of the test developed in K and in F. It is important to recognize that this court does not ordinarily grant leave to appeal on the basis that an applicant is dissatisfied with a preceding court's application of an established legal test. The footnote reference there is to the earlier decisions in Mbata and Lorero, and the judgment goes on also to refer to the decision in Mankai, where it was held that the court refused to entertain appeals that seek to challenge only factual findings or incorrect application of the law by the lower courts. That's the issue of whether it raises a constitutional issue. The same principle applies, though, to whether an appeal raises an arguable question of law of general public importance. It, of course, arises because that must be a question of law. And in that context, an applicant for leave to appeal must allege not only that the lower court misapplied the law to the facts, but that it got the law wrong. And that was what this court held in its decision in Jiba. Now this particular principle has important implications for a number of submissions made by my learned friend, Mr. Maneche. It means that questions as to whether significant weight was attached to particular considerations, or whether the Competition Appeal Court decided the matter on the basis of sufficient evidence, or whether the Competition Appeal Court showed sufficient deference, are questions that don't engage this court's appellate jurisdiction. If I can then turn to the third and final principle, before I respond to Justice Jefter's other concern, and that is that it does not necessarily engage this court's jurisdiction merely to allege that a matter involves the interpretation of legislation. Indeed, in Media 24, a majority of this court held that the interpretation of the Competition Act does not, without more, raise a constitutional issue, and it specifically distinguished the Competition Act from legislation such as the Promotion of Administrative Justice Act or the Labour Relations Act. And so with respect, my learned friend's reliance on the case of Betabob is wholly inapposite. Not only did that matter quite squarely involve an interpretive issue in which the Labour Appeal Court had literally split on one interpretation versus another, but it involved the interpretation of a piece of legislation that axiomatically raises constitutional issues. And in addition, in Betabob, the applicant for leave to appeal not only sought an interpretation of the Act, but also had a constitutional challenge to the Act as alternative relief. So the constitutional validity of the legislation at issue in that case was directly challenged. So we submit that Betabob finds no application in this case. Now I say the interpretation of the Competition Act does not, without more, engage this court's jurisdiction. Of course, sometimes the interpretation will, and there have been a number of cases in which the interpretation of provisions of the Competition Act have invoked this court's jurisdiction. Those cases have, for the most part, been cases involving the public power of the Competition Commission and the Competition Tribunal, the ambit of the Commission's investigative powers, questions of legality and virus. And this is not such a case. This is a case that involves an intervention in the determination by the Competition Appeal Court that a particular merger does not give rise to a substantial lessening or prevention of competition. And so the Commission relied on cases like Senwes and SOS Broadcasting in their heads of argument. It appears they don't persist in that now, because those were squarely cases that involved the ambit of the competition authority's lawful powers. Justice Jafta, can I attempt to respond to the first issue you put to my learned friend, Mr. Butler? And as I understand the concern, it is essentially arises from what this court did in Jiba in relation to the costs order, where it held that the Supreme Court of Appeal had sought to apply Section 9 of the Constitution. It misapplied Section 9 of the Constitution to the General Counsel of the Bar's cross appeal in relation to costs. And for that reason, while the court lacked jurisdiction in relation to the main appeal, it had jurisdiction to determine the costs order arising from the misapplication of the lower court of Section 9. Justice Jafta, before I proceed, have I understood the concern correctly?
Yes, you have, Mr. Mbigiwa.
So our submission is that principle doesn't apply in this case, and that's for the following reasons. The SCA in Jiba dismissed the GCB's cross appeal based squarely on Section 9. That was the basis upon which the GCB's cross appeal was dismissed, and that is the basis upon which the GCB sought to overturn the costs order granted by the SCA. In other words, it was the error in the application of a provision of the Constitution which the GCB contended invoked this court's jurisdiction. The high watermark of the application of Section 27 in this case in the Competition Appeal Court is that Justice Rogers held it was relevant to the application of Section 12 capital A3 in determining the public interest impact. The Commission doesn't say that Section 27 shouldn't be applied under Section 12A capital 3. There's no suggestion that the Competition Appeal Court in the application of Section 27 erred. The basis for the appeal is that the Competition Appeal Court misapplied Section 27A1, and in that context, there is no hook in the judgment of the Competition Appeal Court upon which the Commission can rely.
Do you accept, though, that for us to evaluate whether the CAC was correct in its judgment, we will have to consider provisions like Section 27(1) of the Constitution? As I understood Mr. Butler's argument is that he has no quibble with that. It applied Section 27(1) of the Constitution. Do you accept that?
Justice Jafta, I have to accept that, and I do.
So it does raise a constitutional issue in that sense, but your argument is that you don't have jurisdiction because there is no argument or complaint that Section 27(1) was misapplied. Is that your argument?
Indeed, Justice Jafta, and with respect, if I can take the submission a little bit further, what can't be the case is that every time the SCA or the court a quo mentions a constitutional right, that this court's jurisdiction is thereby invoked.
But I understood here the case to be it applied it. It had recourse to constitutional considerations,
yes,
for its decision to be correct, not just mere mention.
Indeed, Justice Jefter. I'm just trying to delineate the principle that emerges from JIBA, and I'm saying it can't be mere mention. It's got to be more. And in my submission, it is that the argument of the appellant is that the court erred in its application of the constitutional provision, and that's precisely what the General Counsel of the Bar submitted in JIBA. That in applying Section 9 to impose a costs order on the GCB, the court erred.
Would a complaint that says the CAC in interpreting, especially the meaning of public interest in Section 12A2, it did not invoke Section 39(2) of the Constitution, would that be raising a constitutional issue?
Justice Jefter, it is what Justice Madlanga referred to in Mbata as clothing a factual dispute in constitutional garb. The matter is not one of constitution of statutory interpretation, and that is revealed by the fact that it's not suggested that Section 12(a) of the Competition Act ought to be interpreted in one way in the context of access to healthcare, and in another way in relation to other goods and services or other industries. There's a suggestion that the Competition Appeal Court failed to interpret in terms of Section 39(2), but without any concrete demonstration of what the two interpretive options which the court faced are.
Finally, do you accept that since we have agreed that Section 27(1) of the Constitution is implicated, do you accept then that the duty or obligation sitting in Section 39(2) is triggered when we interpret Section 12(a), especially 2, sub 2?
Justice Jefter, I don't accept that. And the reason I don't accept that is it goes back to a question that Justice Madlanga asked very early on in this hearing, with respect to which I haven't heard a very clear answer. Justice Madlanga drew a distinction between the application and the interpretation of the Act. And he put to Mr. Maneche that his application argument was very clear, but that his interpretive argument was not. And the interpretive argument remains opaque. I accept that Section 27 is relevant to the application of Section 12(a) on the facts of this case. But interpretation is an objective exercise that applies to a statute. Section 12(a) is not a healthcare statute, it's a healthcare provision. It's not an education provision. It's not a social services provision. It is a provision that deals with substantial lessening and prevention of competition and substantial public interest harm. And so to frame it as an interpretive exercise, with respect, I submit is a mistake, because it must bear a consistent meaning in every case in which it's applied, although it can be applied on the facts differently.
Thank you.
Thank you, Justice Jefter. Chief Justice, Justices, if there are no further questions, those are my submissions on jurisdiction.
Thank you, Mr. Mbikiwa. Mr. Manager.
Thank you, Chief Justice and Justice of the Court. I'll have a couple of points that I'll address. The first is the interpretive question which my learned friend, Mr. Butler, addressed in relation to 12(a)(1)(a). And that in part addresses the question of jurisdiction. You would have seen during the debate that my learned friend did engage in what a proper interpretation of Section 12(a)(1)(a) should be. But we just highlight that in doing so, he did not attempt to defend the approach in paragraphs 98 and 99 and 125 of the Keck judgment. In other words, he did not say to the court that the only time that a price effect is relevant under the competition assessment is if it results from a change in market structure, which is the approach that the Keck adopted. He sought to contend that on a different interpretation, looking at the structure and language of the Act, that a tariff increase that results automatically, or price increase that results automatically from the restructuring of the two entities does not fall under 12A 1A. In other words, he advanced his own interpretation, which is not the same interpretation that the Keck adopted in paragraphs 98 and 99 and 125. The importance about that is that in the debate, it's clear that there is an interpretation question, which is an arguable point of law, and that it is an arguable point of law arises also from the fact that he doesn't try to defend the approach of the Keck in the paragraphs 98 and 99 and 125. But what he did is to make a very important concession. It is that indeed the price increase will result in a reaction by life Encron, which may result in prices increasing, which is an SLC. He accepts that. And he refers to paragraph 137 of the Keck judgment and wants to suggest to the court that, look, the Keck actually did a competition analysis, but he forgets that the Keck started off by saying that because the price increase is not the result of a change in market structure, it's irrelevant to the competition assessment. It only results under the public interest consideration. But his concession shows that the Keck misdirected itself on the interpretive question, that in fact, its finding at paragraph 137 is clear indication of an acceptance that the merger has the effect of producing a lessening of competition. The problem with the approach of our learned friend is he keeps saying to the court, you must ask yourself, does the price increase result from an SLC? He's inverting the inquiry. The inquiry is not, when you see a price increase, the question is, does the price increase result from an SLC? So you can apply, you can assess under 12 capital A1A. The question is, does the merger, the transaction, results in an SLC? Now on his concession, it's quite clear. The causal connection is clear. The merger raises prices in Plexstock for uninsured patients, and that he accepts might result in life Encron increasing prices, in other words, dampening competition, and that is a lessening of competition and should have been assessed under 12 capital A1A. So it's clear from that concession that the Keck was wrong, misdirected itself on the interpretation question, and this court must set that right. Even if
is it a lessening of competition, or does it do so in a substantial way?
Well, that's the second inquiry. So first, he says it's irrelevant because it's not a competition inquiry. So we say he's wrong on the starting blocks. He doesn't even go further to assess whether that lessening might be substantial because he says it's not a competition assessment. But our submission is, had he considered whether it is a competition assessment, and here I adopt my learned friend's submission that substantiality under 12A1A means materiality, assuming that to be correct. We've said that one must adopt a lesser hurdle, but assuming that is the hurdle, he says, we say our submission is if he accepts that the price increase will result in a hiking of prices by life Encron and depriving uninsured patients of the choice between the cheaper hospitals and bargaining prices who are vulnerable and are not protected by medical schemes, that is indeed material to competition in that market, because the CAC says the market is narrow. In that market, you only have the target hospitals and Life Encron. So if all of them raise prices, the effect on consumer welfare is material. Even on a pure competition analysis, which they say exists parallel to the Constitution, we submit that that's wrong, because the importance of the market will always be relevant once the court is aware, and that's McCarthy, once the court is aware that its interpretation will affect a constitutional right, the Section 39(2) obligation is a non-negotiable for courts. And when would one say a constitutional issue arises? When the judiciary itself does not comply with its constitutional obligation under 39(2). At the interpretive level, our learned friend, Mr. Mbikiwa, says, but we just, we're not linking this complaint about 39(2) to any interpretation, but we're going there to the interpretation. So that's the first point. So that on the arguable point of law, it is an arguable point of law, and the prospects are clear from our learned friends stepping away from defending the narrow approach of the CAC at paragraphs 98, 99, and 125, which has no patches under the language and structure and purposes and context of the Competition Act, and is in contrast, contrary to the approach in the Mondi judgment, which are referenced to this court at paragraphs 47 to 48, which says, always have regard to our purpose, the purpose of our own act, because it's different from other jurisdictions. So that's the first. The second point on jurisdiction, sorry, Justice Madlanga. Oh, sorry, I thought you wanted to ask a question. I beg your pardon. Then, in relation to our learned friend's response about why, Mr. Mbikiwa, why this is not a constitutional issue, he raised three matters. The one is
Mr. Manager, yes, you read my mind correctly.
Yes.
It's just that I was still trying to organize my thoughts. I'm interested to know if your argument means Section 12(a)(1), that is its meaning rather, is as elastic as there may be constitutional rights that bear relevance to its interpretation in accordance with whatever the industry we are concerned with may be. Here you say Section 27 because we happen to be in the sphere of health, but the section applies generally all possible industries or areas of commerce or whatever other human endeavor. So in some other industry, it may be a different right, and in another a different right. And so basically the meaning is as elastic as there are rights that may bear relevance to the interpretative exercise.
Here, Justice Madlanga, might fall into the trap that Mr. Mbikiwa was putting, that there's a very close relationship between interpretation and application in the question Justice Madlanga asks. I accept that the standard of materiality will not, it'll always be material, but the content of what that is may change depending on the nature of the market you're dealing with. So if you're dealing with a highly concentrated market, what is material to competition might be different. One might say that touches on evaluation, but it also touches on what is that content of that standard? What is the normative content of that standard? If you're dealing with a major in different industries, the content might be different. But and that is why in these kinds of cases you have these large volumes, because you are trying to understand the particular markets and what drives those markets. And so the standard of materiality must be, the content must be specific to what you're dealing with. So you can't say, well, if you have a narrow market like Klerksdorp, which is a local market, and there are going to be substantial price increases because there's going to be a dampening of competition between the two hospitals. And when that affects critically the right of healthcare in this case, or differently, if it was for the supply of something different, but the impact is the same, that you're going to have a price increase. It's possible that in the one set of circumstances, that normative standard might produce a result that the lessening of competition is not substantial, and also having regard to the factors under subsection 2. So I do accept that it touches on both the interpretation and the evaluation, but we submit the section 27 is relevant to the content. So you're not going to adopt an interpretation which negates access, the right of access to healthcare. We accept that this is not a healthcare statute, but that's why the Constitution says when you interpret any statute, if it has enough effect on a right, you must have regard to section 39(2). So it is not only if you interpret a section that affects that's relevant, that operates in the industry relevant to that particular right. It's any right, any statute, if it has an impact on any right, you must have regard to 39(2). And when it comes to the public interest, the failure of the CAC is clear, because although it refers to section 27, it doesn't hit its obligation under 39(2), that it must then construe that section in a manner that does not negatively affect the right of healthcare. And our complaint is indeed that the judgment and the order which flows from the approach the CAC adopted threatens the right of access to healthcare. That's our concern. And we say that is a constitutional issue. So that's our response first on the interpretive question and on the jurisdiction issue. Then our learned friend is faced with the problem in relation to uninsured patients that paragraph 25 remains unevaluated by the CAC. So what does he do? He goes to the table at page 3556 and tries to suggest, reading the table, that you must add up these numbers such that the CPE increase, and that's the CPE increase on the final bill. We're not talking about a portion of the bill. We're talking about the final bill has that significant increase. But, and Justice Matlanga did ask a right question. What are you asking me to do? Must I add 6 upon these numbers? How do this then pan out in relation to those at paragraph 25? Now, you should first find the answer in the judgment. There is no answer. That's why our learned friend goes to this. But what he doesn't do with respect is to go through with the exercise and look at what the judgment in fact says of that assessment from paragraph 201 of the judgment, which is 3558. You will see at paragraph 201 that what the court says, I've explained my reasons for preferring IEC's methodology to AF's and why day cases should be included. So he's preferring the more experienced actuary over the not so experienced. I'm surprised that when day cases under 24 hours are excluded, the percentage by which Mediclinic is more efficient goes up rather than down, since I would have expected Mediclinic's discounted tariff under the 23-hour rule to have resulted in Mediclinic being at its most efficient when all admissions, including this class of day case, were counted. Subsequent to the hearing of the appeal, the appellant's counsel were asked to deal with this apparent anomaly in a written note. Since the commission was not amenable to the appellant's counsel including any material in the written note which could not be derived from the record, counsel's somewhat cryptic note has not clarified the matter. That problem he raises is that if you look at the table, you'll see that it compares efficiencies where day cases are included and efficiencies where day cases are excluded based on the less than 24-hour rule. That was the debate the economists had about the extent of the market, whether the market includes patients who don't stay overnight or maybe for 24 hours. And the hospitals use different rules, so it was difficult to agree on a rule to apply. But what Mediclinic said is that their tariff for day cases are cheaper. So when this comparison is done under the top table and the bottom table, the CAC quite rightly expected that when the day cases are included, there must be a change to the efficiency level. He says he expected that the efficiency would go up rather than down. But it goes the other way around. So he's perplexed. He asked for clarification. The note given still doesn't clarify. So he's got a problem himself as the CAC with these tables. But then he says, be that as it may, so despite all of those problems, based on the 7 hospital comparator, the inclusion of all day cases in IAS methodology, one may reasonably expect that the net effect of the merger and the implementation of Mediclinic's efficiency initiatives will be that despite the implementation of Mediclinic's higher tariffs, CPE at the target will fall by about 6%. That's the reduction he's putting in. Then he goes, 203, since the factual evidence about Mediclinic's efficiency initiatives was compelling, there is no reason to be skeptical about the figures reflected in the above table. Of course, these figures do not take account of the beneficial effect for the targets of the procurement exemption. On the most meaningful of the actuarial comparisons, IAC calculated Mediclinic to be cheaper by 6%. The tribunal found Mediclinic to be more efficient than the targets in procurement by an amount which would reduce the targets by 6.2%. On IA's primary scenario, including all day cases, CPE at the targets under Mediclinic control would thus only rise by 0.2% if one assumes that without the merger, the targets would achieve procurement efficiencies for 2 years of 6.2%. On the day case exclusion, which was the approach taken by the tribunal and the commission, the targets would be cheaper than under Mediclinic control, even if one assumes that the targets would achieve procurement efficiencies of 6.2%. Then he says, on AF's calculations of the primary scenario, including all day cases, the beneficial effect for the targets of the procurement efficiency would have to exceed 4% before one could find that the merger will increase the target CPE during the grace period. It is doubtful that the procurement would yield an efficiency of 4.0%. If it did, it would only be for a portion of the grace period. So on AF's calculations, there is a possibility, though not a very large one, that for part of the grace period, the target CPE under Mediclinic control will be higher than under Matlosana's control by an amount not exceeding 2.2%. Then he says, 205, I do not lose sight of the fact that just as it might take some time for NHN to attain its maximum procurement benefit for the procurement exemption, so not all of Mediclinic's efficiencies could be achieved immediately. The greater part of its efficiencies in relation to surgicals is a procurement efficiency rather than utilization efficiency. The procurement efficiency will be achieved immediately because Mediclinic's procurement systems are mature and in place. There will be a lag in achieving utilization efficiencies in tariff items, surgicals and ethicals, since this requires the collation and analysis of data and engagement with specialists. Dr. Smart says that it took about 3 months for any initiatives to yield positive results. It could be significantly longer. Then he says, the beneficial effects for schemes of ARMs are not accounted for in the above quantification, in that table. Since schemes have negotiated ARMs more extensively with Mediclinic than with NHN, the post-merger implementation of these arms at the targets could be expected to have some further beneficial, though unquantified, effect on the cost of scheme claims. So you can't quantify them. In my opinion, the tribunal erred in finding that there were substantial public interest grounds for prohibiting the merger on the strength of price effects. Again, you will see he doesn't deal with the facts under paragraph 25. But the best case scenario for the merging parties is that he says they will offset any price increase by about 6% of efficiencies. They'll offset any tariff increase by about 6%. So when you go back to paragraph 25, you know from the findings made by the CAC not the submissions of my learned friend. He says you're bound by these findings. The findings made by the CAC is at best, there's a 6.6% offsetting. Now, when you go back to the uninsured, because the court doesn't discuss them, you can only subtract 6% from that CP increase under paragraph 25. You are left with double-digit numbers because of the variance that I showed you. You are left with double-digit numbers. Now, he submits with respect that taking the Constitution into account, and he says that the CAC was faithful to the Constitution. Taking the Constitution into account, this court must uphold a finding that significant price increase of a vulnerable group, that's the CAC says so, who there's no evidence they have money, and contrary to what my learned friend submitted, there's no such evidence in this record, that they made the choice to forego medical scheme cover. And Justice Jafta is quite right. The reality in this country is that the majority of people who seek healthcare cannot afford private healthcare. So the effect of this judgment, if you uphold the measure, is that even the few that can afford and may afford in future, because the targets can provide cheaper prices, must be denied that access. Because that is the effect of the judgment. That's why we say it breaches, it threatens the constitutional right. It is eminently within this jurisdiction of this court. Now, what is the answer we get? Is there is a condition which says they're going to apply this, and that condition will be for 5 years. Now, realizing that there is a fundamental problem because it is a remedy for 5 years only, not that will last. And after 5 years, these patients will be exposed to the same high prices. He says this court must now extend the time period to be perpetual. Now, I've submitted to this court that first, we say the CAC misdirected itself in interfering with the remedial discretion. Unless this court upholds that interference, it can't compound the problem by interfering further with that remedial discretion. Now, my learned friend has a big problem because, like with the efficiencies regarding uninsured patients, the CAC simply did not discuss the manner in which the tribunal misdirected itself on remedy. Nowhere. And there's a simple reason for that, is that at paragraph 213, it wrongly said it is at large to do what it wishes to do, to decide the matter afresh. Now, my learned friend says, but if you look at the reasons given in the CAC, you will find some reasons which show that the tribunal misdirected itself. Of course, this court is not here to reconstruct the judgment of the CAC. It is to look at the CAC and say, did it apply the proper test? And the proper test is in Mwelase, paragraph 68. Unless you can show that the discretion was not exercised judicially, you cannot interfere. I was at the receiving end of the court in that matter because I was supporting an interference with the remedial discretion of the Land Claims Court, which is also a specialist court. And this court reminded everybody that that is an important remedial power. It is a true discretion. You only interfere if you can show that the exercise of discretion was not judicial. And there is no case, there's no explanation of that in the CAC judgment. There's no case that they tried to make in the CAC or tried to make before this court. My learned friend is just at the back of his argument trying to find something, but that's not how one litigates.
Does the difference not lie in the fact that the CAC held that there is no SLC? And once it holds that, then out of the several possible remedies, it is at large in that sense. Of course, I know your argument is that it was wrong even in holding that there was no LLC. But doesn't the difference lie there?
Justice Madanga is right. That's the first place to find the difference. But that difference is not the full story, because having said that, you've seen that he repeatedly says that there may be a slight increase in prices. And that explains why he goes further and imposes conditions. if he was so confident that there will not be an SLC and no SPI, as my learned friend refers to it, the court would have followed the judgment in Emery's, that then you are bound to approve the measure. He would be saying that, tribunal, you were wrong, you were bound to approve the measure because there's no SLC and there's no SPI. But he's trying to cover all bases. He says there is no SLC, there is no SPI, but I have a little niggling concern that prices might go up in the grace period, and therefore I'm imposing a condition. He's interfering with the discretion. That's why my learned friend has to go and try to find little bits of sentences here and there and say, well, there's a misdirection, there's a misdirection. With respect, there isn't such. So that's our response on the question of remedy, that in fact, there is no case that there was any failure to apply this judicially. And let me just check if there's any issue that I need to raise. Yes, and we would, on issues such as the response of the various medical schemes, my learned friend put a lot of emphasis to discovery health, especially in relation to alternative reimbursement models. In our heads of argument, we've dealt with that to show that on its own evidence, Mr. Bass of Mediclinic showed that, in fact, alternative reimbursement models are not that an extensive part of its business. It's about 30% of its business. Secondly, that the NHN is also implementing alternative reimbursement models. But thirdly, that it may be good for a big medical scheme like Discovery Health with countervailing power when it negotiates with these hospitals, but is different for smaller schemes. And you'll recall the experience of Bonitas is that it says Mediclinic implemented ARMs and Bonitas found that they were too expensive. And the reason, the biggest problem it experienced was lack of transparency in information. So it wasn't getting enough information from the Mediclinic to assess whether these fixed fees were working well or not. And it had to terminate fixed fees and go back to fee for service. So it's not a magic. The fact that they refer to Discovery Health, one can't end the inquiry by looking at the largest medical scheme with sophisticated actuaries and systems and the like. You've got to look also at the smaller schemes. And here the minority judgment highlights the position of Anglo Gold, which is a mining company catering for 10,000 mine workers who would be adversely affected by this merger because prices are likely to increase. And that in the minority judgments, we would submit that it's important for the court to have regard to that assessment because one can't only look at competition from the point of view of the largest scheme. Even that largest scheme, we emphasize that largest scheme in the Commission's report on remedies, which is, I think, is in volume 16. I just want to give the court the reference. Yes, it's in volume 16 at page 1566. The court will find the report of the Commission, which was submitted to the tribunal on remedies after it had received the comments of the medical schemes. And in there, you will see that Discovery now said it had concerns with this measure and did not believe that the remedy would be effective. So there's not one story for Discovery Health, there are two stories and both of them must be considered. And so our submission really is this, that on the position of the uninsured patients, our learned friends for the respondents simply do not have an answer on the misdirection on SLC, on the findings on public interest, both as matters of law and as a matter of remedy and interference. On insured patients, the argument really turns on, are you reversing, would you accept the CAC's reversal of the tribunal's decision that the actuarial calculations were of no assistance to its predictive judgment? And secondly, how you factor in the counterfactual, in other words, the procurement exemption. That's it. But there's no answer on uninsured. And you can't cut up that market and say we approve the measure for the insured. As they said, the hospitals provide services to all uninsured and insured as one body. So the problem you have for one affects the question whether you approve the measure. If things should change, they can come back and seek approval for the measure in 5 years' time, or so much time as there is entry. So our submission with great respect is that the CAC misdirected itself in the manner in which it interfered with the tribunal's decision at various levels and checked its constitutional responsibility, and that the appeal, leave to appeal, should be granted and the appeal upheld, and that judgment is reversed with a dismissal of the appeal with costs. Those are submissions, unless there are further questions from the court.
Thank you, Mr. Manager.
Yes, the court pleases.
Judgment is reserved and corrigens.
We thank you for the indulgence of the court.
Today's proceedings have concluded. The host will now terminate the meeting.